Our first case, number 22-1659. Counsel, whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the Court. David Zients on behalf of Bacardi. Congress enacted mandatory requirements for renewing a trademark registration and did not grant the PTO authority to waive those requirements. Bacardi claims that the PTO exceeded this limit on its authority, awarding a renewal, even though the statutory requirements were not met within the statutory timeframe. The question on this appeal is whether that claim is reviewable. Consistent with the strong presumption favoring judicial review, the answer is yes. The parties now agree that nothing in the Lanham Act expressly precludes judicial review. There is also no clear and convincing indication in the structure of the statute that preclusion must be implied. Further, in addition to its APA cause of action, Bacardi asserts a non-statutory cause of action challenging the PTO's action here as ultra-virus, and the PTO does not defend the district court's sole ground for dismissing that claim. For these reasons, the district court's decision should be reversed, and Bacardi should have an opportunity to present its claim on the merits. Your Honor, if I could begin with the structural issue, because I think that is the heart of what the PTO is now arguing on appeal, this idea that you imply preclusion here from structure. And the key question here, in light of the strong presumption favoring review, is not whether an inference could be drawn, even a reasonable or plausible inference could be drawn from the structure of the statute saying that this renewal action was meant to be outside of judicial review. It's the opposite. That needs to be the only possible reasonable inference. If there is another inference out there, at least a reasonable one, that review is not precluded, then the presumption prevails. And what I would submit, there is at least, in my view, it's the best inference, but certainly a reasonable inference that an agency action unlawfully renewing a trademark registration simply falls outside of the cancellation mechanism that is for other issues.
Think about, this may be a little far afield, but do we think about the sort of implied preclusion differently, and if so, how, from implied preemption? I mean, they seem to have sort of overlapping ideas, but the court doesn't seem to talk about them in precisely the same way. Do you have thoughts about whether those are different, and if so, why?
Sure, I think it is a bit different. Applied preemption often comes, in the context where, you can't comply with federal law and state law at the same time. So one of them has to give way, and that's going to be state law rather than federal law.
It sort of claims the field, right? We think about implied preemption too, where federal law claims the field, right? And that feels a lot like what we're talking about here, right? That you might find preclusion in a scenario where the structure sort of claims the field, right?
Right, but Your Honor, I think if we're following that analogy, the Supreme Court in recent years has really strongly disfavored this idea of claims the field preemption. You really have to find it's basically impossible to comply with both in the preemption space, and there's a strong, another analogy there, there's a strong presumption against preemption in those implied preemption cases. So I think
that's sort of what I'm getting at, right? Is that, and this is helping you, not hurting you, right? So, but
sure.
the point is the Supreme Court has suggested in the preemption context that maybe there's this narrow window that's available here, but it's a really narrow window, maybe just a theoretical one. And why wouldn't we think the same thing in the idea of implied preclusion?
Yeah, I think that analogy is a good one in the sense that the Supreme Court.
I'm not shocked that you think it's a good one.
I've learned to recognize a friendly question. I think that. There's very similar principles in terms of a strong preemption. When you look at the preclusion cases, there's a very similar idea that it's narrow. The case that we discussed in both briefs is the Block case, and I think the really important lesson from that decision and some of the circuit court decisions that have followed, you can't imply preclusion just because there is a remedy in certain circumstances. It comes with limits. This falls outside the limits, so Congress must have intended that this other action must be not reviewable. In Block, you had this really intricate scheme that essentially would have become nonsensical if you had the particular type of review at issue. So you had the milk handlers, the milk producers, and the milk consumers. And the handlers and the consumers were basically hand in glove with the same interest. And Congress said for the handlers, you have to go through this intricate administrative scheme, and only after that can you seek judicial review. And the consumers who handlers if they consume milk, they could be a consumer too, could basically just circumvent that entire process, challenge the exact same agency action. And that's what Congress, the Supreme Court said, that there's sort of the only way to read this statute is that it precludes that type of review. But notably, the DC Circuit had a case about 10, 15 years ago called Arkansas Dairy Cooperative versus Department of Agriculture. It considered the exact same statute, and then instead it looked at it from the perspective of the producers. And the producers were just kind of left outside of that statutory scheme. Unlike the handlers, there was no express provision for judicial review. The DC Circuit there said that's different. We resort to the strong presumption on review. There's no, you're not aligned with anyone else who has a right to review, so you can just go in under the APA. And I think that's actually much more analogous to what we have here.
If this was a cancellation, where would we be?
Your Honor, if there were a substantive challenge to the registration of the mark, then you would have a cancellation proceeding that would go before the TTAB, and then you would go under 15 U.S. Code Section 1071 to challenge that action. So I think that literally where we would be in the kind of action authorized by 1071 to review the TTAB cancellation
Is there any
proceeding.
court that has talked about setting aside a registration renewal as an action separate from a cancellation?
Your Honor, I don't think this has come up one way or the other for the simple reason that...
If it hasn't come up, what do you mean one way or the other?
Well, what I mean is that we do have actions, on the other side where the PTO has followed the law and refused to renew a registration when the statutory requirements for doing so were not
But you're
met.
making a distinction here that I haven't seen anywhere else, and that's what I'm trying to get at.
Your Honor, I agree. This is not a distinction that you'll find in a case. Just I think the way Congress structured the statute is that it was supposed to be automatic. When Congress and other parts of the statutory text talks about the word cancellation, with respect to renewal, Section 1058 just says a registration lasts for 10 years, and then Section 1059 imposes the requirements. They're not particularly difficult requirements, but courts for decades have said this is not discretionary, this is not technical. If these requirements aren't met, the PTO has no authority to extend the statutory requirements or deadlines. So it's just a different action. And I think we sort of fall back to this strong presumption of review. It's just a matter of silence. It is not specifically addressed. I think there's good reason that this wasn't addressed as a matter of cancellation, precisely because it's supposed to be automatic. It just expires. That's what the statute indicates, that the regulation is expressed, that when the statutory requirements for renewal aren't met, the registration expires, and that's just that.
What, if anything, should we make of the fact that 1071 specifically lists applicants for renewal, a dissatisfied applicant for renewal among the parties who can bring an action?
Your Honor, I think that is the exact type of circumstance that's covered by these Supreme Court decisions. It says the fact that you have an express remedy for one circumstance, one party, is not enough to support implied preclusion. I think it's actually basically exactly like the DC Circuit, Arkansas Dairy Cooperative case that I mentioned earlier. There you had that milk statute, which has an express, route for appeal for the handlers, but it just leaves the producers out of it. And the DC Circuit says the producers go under the APA.
So 1071, it lists the applicants for renewal and kind of a list of parties to the proceeding in front of the agency, right, who might have been aggrieved. But you're saying that doesn't mean we should read it as an exclusive list that somehow says the APA doesn't apply.
No, Your Honor, I think that would be too much to that's not enough to overcome the strong presumption favoring review. Now it does mean that review is different. Section 1071 is a sort of uniquely favorable way to the challenger of seeking review. It's de novo review in the district court. You can even, unusually for challenging agency actions, you can put forward new evidence. So, we don't claim the benefit of that special form of judicial review under 1071, but I don't think that supports as the only possible inference from the statutory structure that Bacardi has no ability to seek review. And again, I think what the cases also highlight is how extraordinary it is to say that a claim that an agency has exceeded its statutory authority could be totally unreviewable. That is central to the Block case that we talked about, where someone who is directly aligned with the consumers there, had a basis to seek judicial review. The Second Circuit in the Clapper case, reads Block and notes how important it is that there was someone aligned with the party seeking review there that could pursue the exact same claim. So it really would be extraordinary, I think, to say, Bacardi may very well have a claim here that the agency acted outside of its statutory authority, did the direct opposite of what notice and comment regulations promulgated by the agency said it was supposed to do. And there's just no one who can challenge that agency overreach. That's the lesson of all these cases. It comes up again in these it's in the express preclusion context, but the recent line of cases at the Supreme Court, the SAS Institute case, even where Congress, has, one might think you would read an express preclusion statute to preclude the types of review that were sought there. The Supreme Court in recent cases has really gone out of its way to say, well, of course, when you're challenging that the agency doesn't have a basis under the statute to do what it did, the shenanigans was the word. That's what the APA is for. And I'd suggest that if that's how you approach it when Congress, in text, enacts a preclusion of review provision, that principle should apply at least as forcefully in the context where we're just drawing inferences from structure or something else. Your Honor, I did want to touch briefly on the patent analogy that the government draws, and I think it's a very similar set of issues to what we talked about in terms of the Block case. The lead case from the Federal Circuit that they rely on, Pregus, tried to bring an APA cause of action to challenge whether a patent should have been granted because it was obvious and there was prior art. Congress very meticulously addressed how courts are supposed to review exactly that issue, non-obvious patents, that requirement for patentability. And that would be this sort of where it would be kind of nonsensical to have an APA cause of action where have these administrative mechanisms to bring this exact type of challenge within the PTO. Congress actually said, but a decision by the agency not to institute that type of review is non-reviewable. You could basically totally get around that and do exactly what Congress contemplated could not be done through that sort of process. So I think it's very different. And the other point I would make just to highlight about the patent analogy that the government draws, patents aren't renewable. We have those cases all involve whether a patent should be invalidated. There's a process for that exact question, the statutory requirements for the validity and granting of a patent. There is no separate provision in the Patent Act saying, here's the separate renewal process and here's what you have to do. Here you have really distinct statutory events in the Lanham Act. You have registration, you have the substantive requirements of registration, you have a cancellation process where a party claims that doesn't meet those requirements.
Can I just ask you, what
yes.
do you make of the Bonehead Brands, the case you cite,
Mm-hmm.
the cancellation because of a failure to comply with 1058 is not automatic?
Your Honor, I think that speaks to Congress crafted cancellation procedures to deal with a specific set of issues, principally the the substantive registrability of a trademark. Section 1058 is a bit different. It's an instruction not to institute cancellation proceedings by a party, but instead a directive to the PTO director that in certain circumstances they have to take action. But I think it just sort of confirms that you have a subset, a very large subset that, Congress. A very large subset of agency actions do fall within these cancellation proceedings. Another way this is unlike the Patent Act is that, within 5 years after registration, cancellation can be sought on any ground. So I think broadly there is a policy favoring review, but it doesn't cover, every single facet of the statute. Section 1058, the affidavit requirement, and then as relevant here, Section 1059, the renewal requirement. It's just not covered. And it's sort of a quirk of timing in a way that it's not covered by the cancellation provision, because a renewal by definition can't happen until 10 years. Or a failure to renew, and so you're sort of outside the 5-year statute of limitations the day that happens. And so we're just back to the point that it would really be doing quite a lot of work and much more work than would be consistent with this presumption favoring review to say, well, because of this quirk of timing, that a renewal action just automatically just becomes non-reviewable because it's past the statute of limitations for the separate and distinct cancellation process. Thank you, Your Honors.
May it please the court, Nicholas Crown for the USPTO and Director. If I may, I'd like to start with 3 points which I think get to the heart of this case. The first is that the Lanham Act contains a comprehensive scheme through which a third party like Bacardi can challenge a registration and seek to have it removed from the books. And I want to emphasize that point because Bacardi's arguments in its brief, and I think in the remarks today, suggest that renewals somehow fall categorically outside of that comprehensive review scheme, but that's simply not the case. I think as the PTO explained to Bacardi in its inter partes proceedings, as Bacardi is currently litigating in its pending lawsuit in the District of Columbia, there certainly is a ground for cancellation of a registration if the renewal was procured by fraud. So this notion that there's somehow a lawless zone or unreviewable conduct or that this is a gap in the statutory scheme, I think that's inaccurate. And that point undermines most of Bacardi's theory in this case.
Well, they're not arguing, would you agree, they're not arguing in this case about conduct by the mark owner, fraud. They're not arguing that the mark itself is deficient, right? They're arguing in this suit about agency action, agency allegedly not complying with its own rules and procedures, which is what the APA is built for.
Well, just to push back on that a little bit, Judge Rushing, I think in a way Bacardi is challenging the registrant's actions, because if we look at the provision of the Lanham Act that Bacardi relies on for its substantive claims here and the ultra vires claim, it's 1059, and Section 1059 actually sets out the requirements for an applicant. It doesn't actually impose a mandatory obligation on the agency. In fact, 1059A states that any deficiencies in the application filed by the registrant can be cured. So I think that's another important point. The second point I wanted to make.
Do you agree that this is not a cancellation action? They're not pointing to any deficiency with the mark, right? And saying this should never be a trademark or it shouldn't currently be a trademark because it's not being used that way. Do you agree that this is different than a cancellation claim?
No, we disagree. We think in substance, in all relevant respects, this has the hallmarks of a cancellation proceeding. And that's one of the insights the district court made here, and that's certainly.
Well, that has the hallmarks. Tell me about that. The district court said this is a cancellation proceeding. It's exactly the same, but that seems debatable.
Well, and I think this actually is something that Bacardi concedes in footnote 2 of the reply brief at page 10. I think the parties agree.
That would be surprising, don't you think?
I think the agreement, the party where they agree, and this is kind of the linchpin, I think, of the argument. we all agree, if this is the type of claim, if Bacardi is seeking here to bring the type of claim that Congress intended to channel through cancellation procedures, then Bacardi would have to go through that intricate scheme. And I think here, if we take a step back and look at what the claim is, we have a third party who is challenging a registration that is currently on the books, and they want to have that registration removed from the books. That is the premise of a cancellation proceeding. That's I think, A to Z, a cancellation.
A very high-level view of anything that suggests this mark shouldn't still be going is a cancellation. If they're saying it should have expired and the agency acted outside of its authority, you're saying at a very, very, very high level, that's saying the mark should no longer be on the books, so it's a cancellation.
Well, I want to bracket the merits, and just on the point, I guess the question on altitude of how far up we're looking, I don't think so. I think either way you look at it, whether you're looking at it from 10,000 feet or zoom in on the claims here, if we look at paragraph 113, that's the prayer for relief in the complaint, they actually mirror the same type of language in the cancellation proceeding they brought.
The same relief, yeah.
Precisely, Judge Motz. And I think that is another important point that underscores they're really seeking the same thing here. And this is the second observation I wanted to make at the start. What Bacardi is seeking to do here with its APA and ultra vires claim in this parallel litigation that's alongside its District of Columbia proceedings, what it's seeking to do here is far removed from any substantive interest as a third party it has. It's trying to collaterally attack the USPTO's collection of fees from another party. And that's a process in which Bacardi has no substantive or legitimate interest and certainly no statutorily prescribed role. And the third point I wanted to make is that the reason Bacardi is asking this court to recognize a freestanding claim outside of Congress's intricate scheme is because really what they have is a theory in search of a cause of action. Their concern is, well, they're foreclosed under the Lanham Act from bringing this particular theory to challenge the registration. So therefore, a new cause of action has to be recognized. But I think that gets it exactly backwards, as the district court correctly found. And again, just stepping back, I want to get back.
I guess the problem, though, is, as kind of Judge Richardson was getting at, is it's not as though the Lanham Act is the only statute. I mean, the APA is, Congress has put both of these statutory schemes in place, and our job is to honor them both and figure out how they interact. And so the idea that we should presume because it's not in the Lanham Act, it doesn't exist, seems a bit too far.
Well, I again want to push back a little bit on that notion. Yes, it's certainly true the APA and the Lanham Act both exist, and we can read them in harmony. But I want to get back to the standard here. What Bacardi is advocating here, I think, is actually a standard of that has never actually been recognized by the Supreme Court. What I heard my friends say is that if there is any plausible reading of the Lanham Act to permit an APA cause of action, then the APA has to prevail. But that's actually the precise argument that the Supreme Court rejected in the same Block case that Bacardi has invoked again today. There, the Supreme Court said that the clear and convincing indication standard, it's not really an evidentiary test or even clear and convincing evidence. What it means is you have to be able to fairly discern congressional intent, and you have to look at that based on the text of the statute, the structure, the legislative history, the purposes of the statute, all of those things together. And I think here, again, if we narrow in and zoom in, Judge Rushing, again, getting back to the altitude point on what the claim actually is here, it's so ancillary, so far removed from any substantive disputes over a trademark registration's validity that it seems perfectly reasonable. And I would say that the structure precludes this type of claim, a collateral attack on the collection of fees. And again, this is another insight in the district court's opinion, because when it went through the Article 3 standing analysis, it recognized correctly, and I don't hear any dispute from Bacardi on this point, and certainly not in the briefs, that the basis for Article 3 standing that Bacardi has is its substantive interest in the registered mark. And of course, once we look at it through that lens, it becomes crystal clear that the way for a third party to vindicate their substantive interest in the validity of a trademark registration is cancellation procedures. And if I could just list out some of the statutory provisions that I think provide both the express text and the structure that, that show that there is preclusion here. If we take a look at 1063, that's the provision governing opposition proceedings, which lays out for a third party in Bacardi's shoes, before the registration is ever actually put on the books, a third party like Bacardi has an opportunity to challenge and oppose that registration. 1064 sets out the cancellation proceedings, and I think this is another very important point. 1064 not only lists out the grounds that can be raised within 5 years after the registration of the mark, but it expressly limits what grounds can be raised with respect to a registration after 5 years. And I think that is very important because it shows congressional intent to limit the challenges that can be raised with respect to a registration. And this gets back to the earlier point in terms of this not being some sort of lawless, unreviewable area. Congress expressly stated that one of the grounds that can be raised at any time, one of the timeless grounds, is that the registration has been procured through fraud. And as we cited in the Bose case from the Federal Circuit, which in a turn cites, if you click through all the Westlaw links, it goes back to decades. This is something the PTO told Bacardi in its inter partes proceedings when it was before the agency. A claim that a registration has been procured or renewed through fraud is reviewable.
But what about reviewing the agency's, calculation of the timing, right? Where's the provision to review this action?
Right. And I think that's actually the point, that there is none. And the
My
reason,
question is, because you say this is not as though it's a lawless zone, the fraud, right, has to do with reviewing, again, what the trademark owner's doing. The trademark owner's committing a fraud. But what's the response to the argument that there's no provision for ensuring that the agency is not behaving lawlessly?
I think the response, Judge Rushing, is that's congressional design, that Congress knew what it was doing and it did it
So
intentionally.
this is a lawless zone, but it's intentional. Congress meant to leave it to the agency.
Well, I suppose, I think the response would be registration renewals are not completely unreviewable because, of course, arguments over fraud can be
Anything
brought.
the agency does with respect to those renewals is unreviewable.
I'm not sure. I don't think that would necessarily be correct. And the reason I say that is because I think if an agency, if an examiner finds, for example, let's say that there has been a registered mark and there's a finding, well, it has not become generic, or the argument is it hasn't been abandoned, those determinations, of course, can be reviewed. And it would be reviewed through agency review. You would go up to the director first and then in district court.
Is that the basis for a renewal, though? You're talking about something different, right? That's the basis for a cancellation.
Right, but I think also the question
Judge
of...
Richardson's asking about a renewal.
Right, and I think with renewals, though, the important point is, in terms of the agency process, what we're talking about here is simply the collection of a fee. That's it. And I think not even Bacardi argues that all fee collections should be subject to an APA
Well, if
action.
you're right, that's true. It's just the collection of the fee. But if you're wrong, like there's some timing issues that they've got to do too, right? They got to collect the fee in the right time frame, right? It's not just the collection of the fee, right? Seems like to me that's the whole point.
Well, I think to clarify, Judge Richardson, they have to collect a fee, and of course the application has to be filed within 6 months. It's called the grace period, so you get the 10-year window and you have 6 months after the 10 years in order to file the application. But as the statute makes clear, and this is actually an amendment in 1998 to the statute, so all the cases that my friend cited saying, well, these are requirements that are not waivable, they're talking about something else, and of course they predate the amendments to the statute in 1998, which say that deficiencies can be cured after the statutory deadline. So what happens is you have to file the application, and then the question is, did you cure the deficiency within the time prescribed by the agency? And I think here we take a look at the regulations, and Bacardi's theory, I believe, has shifted a little bit. It's evolved throughout this litigation, but as I understand it now, it was the deficiency had to be corrected within the amount of time that you had to respond to the initial office action, and they cite 37 CFR 2.184. But that's not the right reg. The right reg is actually 185. And then even then, if that's Bacardi's theory, the office actions and the regulations make clear you still get another 6 months in which you can seek review and file a petition with the director. And I think actually if we took Bacardi's theory here to its logical conclusion, it would actually mean that registrations would have to expire before the director even has an opportunity to look at the grounds originally cited for a refused application. So that doesn't make sense. And I think that getting back, Bacardi's theory here really makes a hash out of the comprehensive statutory scheme that Congress set up.
I just want to make sure I'm understanding. That argument that you just made is assuming we reach the merits.
Right.
Right? I mean, we're not, like, that doesn't have any impact on the question we have. Because we're not, I don't believe, going to answer that question whatever we decide today.
Right.
That is a question that either is reviewable, and a court gets to determine if you're right or wrong, right? Or it's non-reviewable, and it doesn't matter what the agency does. The agency could be the one making hash of these regulations, or Bacardi could be, but your point is, it makes no difference. The courts don't get to look at whether hash is being made or an omelet.
Bracketing the APA, I think that point is certainly relevant for their ultra vires claim, because one of the obligations Bacardi has to establish subject matter jurisdiction is that there was a violation of a clear statutory mandate. And
All right, but we're talking about the APA.
Right.
On the APA, all of that is, the argument you're making, you're saying we cannot actually look at that. That is beyond the APA's coverage. If instead of your version, the agency acted arbitrarily with no reasoning and just threw darts at a board to figure out how it worked, it makes no difference. They can do that.
Well, I think if under that hypothetical, that might raise a separate question outside of the APA on what sort of review might be available. I don't think that's the argument here.
Well, no, but you said they're making hash of it. I suspect he thinks you're making hash of it, right? That's what courts do, is they resolve whether the agency's making hash or they're making hash, right? And what you're saying is, you agree somebody's making hash, but you don't want a court to decide it. You want your agency's decision to be final, and in this context, unreviewable.
Well, no, I want to back up and make two clarifications. One, I don't think the agency under any circumstances made any hash, just to bracket that. But I think going back to the APA question.
I mean, that's not shocking, right? You're saying somebody's making hash, right? You say it's them, they say it's you. That's what litigation is, right? I don't know whether they're making hash or not. My point is, you're saying if they are hypothetically making hash, it matters not.
Well, I think because of the question of fee collection is just outside the scope of what Congress intended to be grounds raised to challenge a registration that's currently on the books, grounds brought by third parties who want to remove the registration off the books. And I think I want to get to
what you're saying is there are, I mean, you just said there are these regulations and they require these actions, and your opponent is getting those wrong. Well, that means that there are regulations that require something, right? And the agency is either complying with those or not, right? And that strikes me as the very type of thing that is reviewable.
Well, no, and I think this is the core point here. In terms of the claim Bacardi wants to bring and the remedy they are seeking, they want a registration that has been renewed, it's currently on the principal register. They want it taken off the books. To do that, a district court or the remedy they have to get is cancellation. That's really the only way.
What if they were able to get the court to move quickly enough to decide this before the director granted the renewal? What if the application was timely, but the payment wasn't made, and they were able to somehow get a district court to rule quickly enough before the director renewed it? So I guess it's still on the books because you're waiting for a renewal from an existing registration, but maybe it's in a gray zone. Would that change your answer?
I want to make sure I understand the hypothetical correctly. I think in that circumstance, there might be some problems with administrative exhaustion, because if the director hasn't reviewed the
Right.
underlying petition,
My point is just you're relying heavily on the fact that the director already granted the renewal, but it doesn't seem that timing really has anything to do with your argument.
Well, no, I think the core point here is that it's not surprising or concerning that given the comprehensive scheme here, what we have, and this is true of any registration that's renewed, until there has been a decision made by the director when there's a pending petition, the renewal or the registration stays on the books, and that's for good reason. But I think the core point here, we can take a look at the patent cases, Excella and Pragus. I want to emphasize that Excella actually dealt with a claim very similar to what Bacardi is raising here, that there was an untimely application. And the Federal Circuit said, as it has time and again, that really when we have a comprehensive review scheme that vindicates your substantive interests, either in the validity of a patent in that context or here the validity of a trademark registration, that shows congressional intent. And I want to get back to, I believe it was Judge Richardson's question of whether there's a role or we're looking at just agency action. Congress was well aware of this because in 2020, when it amended the Lanham Act through the Trademark Modernization Act, it expressly noted that there was, before that amendment, no formal process in which there could be ex parte, that is, a dispute raised by a third party and litigated directly in front of the PTO without including the registrant themselves. There was no ex parte process before then. So then Congress went in and it defined specific grounds that can be brought at specific times in particular time windows, and when a third party can challenge the grant of a registration. And I think that indicates Congress was well aware that there was no other proceeding outside of the cancellation inter partes proceeding.
One other question before you finish. So your argument in parts turns on this distinction or finds important this distinction about the fact that the remedy would be the same, even though the review is of different things, the remedy is the same. One might read the Supreme Court's decision in Hawks, which is dealing with the Clean Water Act, or Clean Air Act, one of the two, Clean Water Act. And there were two issues being reviewed, and the court there said that the fact that the remedy was the same, right, no coverage by the Clean Water Act, doesn't mean that there was review. Do you disagree with that reading of Hawks? I mean, it seems to undermine your reliance on the remedy being the same or similar.
Well, I think it's the remedy and the particular thing that's being challenged. And here it truly is the interest that Bacardi has is the substantive interest.
But you agree that the remedy alone doesn't get you there. That Hawks tells us, like, looking at the remedy is it doesn't get us far enough for preclusion purposes.
Well, for 704 in the APA, I think that might be a slightly different argument. It is certainly relevant. It is an indicator that there was preclusion. And I recognize I'm about to
You can always answer the question. Go ahead.
I think here, in terms of the Supreme Court, the really relevant cases here are the Block v. North Dakota case and the Match case. And I think there, the distinction drawn in the Supreme Court case law in those two cases is really what we have here, because in Match, both cases dealt with the Quiet Title Act. And the distinction there is if you were bringing the type of claim that Congress envisioned you to bring through these proceedings. So, for example, if you were seeking to quiet title, then you've got to go through the comprehensive scheme that Congress set up. But if you're raising a different type of claim altogether, then you don't. And I think here, if we take a look, and this really goes back to the district court's insight, the basis for Article III standing here, the interest that Bacardi actually has, it's not in policing the USPTO's fee collections in a collateral posture. It's its own interest in the mark. And that is the premise of a cancellation action. And certainly its arguments regarding the renewal of this same mark, they're going forward in the pending parallel proceedings in the District of Columbia.
Thank you, counsel.
Thank you. We'd ask that the court affirm.
You got a few minutes, counsel.
Thank you, Your Honor. I have 4 points that I would like to make with the rest of my time. First, a suggestion was made that if you look at the prayer for relief, Bacardi is asking for something that looks exactly like cancellation. Respectfully, that's really not the case. This is an APA action. We are seeking to set aside an agency action taken in January of 2016 that granted an administrative petition to renew a trademark registration that, in our view, had already expired by operation of law. If that is set aside, as we asked the court to do under the APA, the PTO has a non-discretionary ministerial obligation to update the registry. And I'm really surprised to hear the PTO say that the only way that can be done is through cancellation. We have in the record at Joint Appendix, I believe it's 36 and 37, a memorandum that's quite comprehensive and sound from the Commissioner of Trademarks explaining exactly how this works, explaining that cancellation and expiration are different, explaining that when a trademark registration expires by operation of law, the legal status of the registration changes automatically. It just happens. No cancellation is necessary, and there's simply a non-discretionary ministerial obligation on the PTO to clean up the registry.
I took his point, maybe uncharitably, but I took his point to be that, well, if it's got the same effect, then it must be the same thing.
Yeah, I think that I think I understand the point the same way. The PTO has recognized, the statute and regulations recognize that that these are different legal actions. A cancellation as a matter of law, changes the legal status of a registration. That is not what we're asking for here. Once the unlawful agency action is set aside, then the trademark registration has simply expired.
I'm sorry, excuse me, maybe I'm misunderstanding your argument. Is there a court that has treated the registration renewal challenge as a distinct action?
No, Your Honor. And this goes back to my response to your earlier question. I recognize this just doesn't come up. The PTO usually follows the law. But when this come up is the cases that we rely on where someone is dissatisfied that the PTO was a little bit too strict and really enforced the letter of these requirements. So I don't have a case one way or the other. I think we're just back
I
to
thought that's what you said, but then I thought what you were saying later was putting that in some shade.
Sure. No, I think,
Okay,
we're
thank you.
we're just in an area where we've got to apply first principles, chiefly the presumption favoring review. I'm running low on time, but if I can quickly tick through my last points. I heard this point, there's no mandatory obligation on the agency to do this. Again, I think that goes to the merits, and I think Judge Richardson, I take your point that, that's what we're trying to argue about is who's making a hash of the statute and the regs, and we think that this should go back to the district court to have an opportunity to do that. I will say, again, when you read the memorandum from the commissioner from 2012, when you read the trademark handbook that talks about the fee is a statutory element of the registration, these deadlines are non-waivable, non-extendable. I do think we're in the right here, but we want to go back in the district court and fight about it. This idea of Bacardi has no legitimate interest, I also have a hard time understanding. This is, trademark registrations are zero sum. Either the Cubans have it or Bacardi has it. And Bacardi was told by the PTO, we can't act, we can't go forward with your application for the exact same mark because someone is standing in the way. So of course there's Article 3 injury here when the agency, that registration that is blocking it, is getting in the way. By operation of law, it was supposed to expire. PTO acted unlawfully, arbitrarily, and capriciously in a way that kept that obstacle in the way. Of course, Bacardi has an interest, and the whole point of this statute is to keep the registry clean, and Bacardi is very much part of that. I see my time is up, so I had a fourth point, but I think...
Give us the fourth one quickly.
Sure. It was just to respond to Judge Rushing's point about the high level of abstraction. And I do agree that, at some level, you can kind of define everything as basically the same. It all looks like, questions about the registration of a trademark. Once you climb up that ladder, I think you really are devaluing the presumption favoring review. The real question here is this specific action, what we claim to be an unlawful renewal, is that renewal reviewable at all? The PTO says it's not. We say it is, and I think that the answer that it is the only answer that's consistent with the broad sweep of the Supreme Court's cases on the strong presumption favoring review. Thank you.
Thank you, counsel. We are pleased that we are now able, for the first time in many, many months, to come down and greet counsel. So we'll do just that. United States versus Odom. Ms. Baldwin, whenever you're ready.
Thank you, Your Honors. Good morning. May it please the Court. Melissa Baldwin on behalf of the appellant Yakotis Odom. Since 1893, it has been error to omit the mens rea requirement from an aiding and abetting instruction as the district court did here. That error was especially damaging here because it turned Mr. Odom's defense that his cousin borrowed his car to commit the robbery into a basis for conviction rather than acquittal. Moreover, the instruction never should have even been given because there wasn't an evidentiary foundation to support it. So here, the government argued and tried the case as one of principal liability, that there was one robber and Mr. Odom was that robber. That same evidence did not also support finding someone else was involved in the robbery and Mr. Odom therefore could be held liable as aiding and abetting the robbery.
How did that affect his substantial rights?
We objected to giving an aiding and abetting instruction, so that is under abuse of discretion. So it's the government's obligation to prove it was harmless error. And so here they can't do it.
Not on the, just so I understand, you objected to the giving of the instruction, but not to the instruction given. So we review the contents of the instruction for plain error. We review the giving of the instruction for an abuse of discretion.
Correct, Your Honor, and that's partially because of Rule 30D, which requires a specific objection to the content of the instructions. So because we didn't lodge an objection to simply reading, aiding and abetting statute, that's for plain error. But we did object and pointed the district court to the lack of evidence to support aiding and abetting. And here—
Can I just ask the question that may have been Judge Motz's question, but maybe not? In light of cases like Moody, where we sort of have two alternative theories under plain error, so if we assume that the jury instruction was plainly erroneous here, but where we've got two theories, one of which we've got a problem with, we tend not to find, the third and fourth prong of plain error review, so long as the one theory here, principal liability, there was sufficient evidence. Can you help me understand on the what's in the instruction argument, how we get to plain error? And we can talk about the abuse of discretion point, but they're separate arguments.
I understand, Your Honor, and part of why it's an abuse of discretion is because the jury here likely did rely on aiding and abetting based on the fact they acquitted of brandishing. Brandishing wasn't contested here, and the instruction was—
So, all right, I want to come back to the question I asked, which you didn't answer, but I'll go to that question. Why do you make the jump that we can assume based on results what the jury did? I mean, we often say that, like, the jury is a black box for a reason. And, you and your colleague here have been in the well of a courtroom enough to know that trying to understand what a jury did based on the results that came out is a fool's errand, right? Like, it is not an effective means of determining what happened in the room. And we don't generally allow courts to do that, right? That's the sort of point, is it is a black box for a reason.
Sure, so 2 points on that, and then I'll go back to Moody and Ali. So the 2 points is, for that question, is first, we assume the jury follows its instructions. And here the jury was told, if the robber displays a firearm to obtain property, that's brandishing. And the jury saw the robber display the gun and heard the cashier testify she handed over the money because a gun was pointed at her face. So, and then the second point being, I don't have to show that the jury actually did rely on aiding and abetting. Here, I have to show a reasonable probability. And the acquittal on brandishing shows a likelihood that the jury did in fact rely on accomplice liability. And the Seventh Circuit similarly relied on a deadlocked count presenting a similar issue to find a reasonable probability of a different outcome in the Cook case. Now I want to go back to the Moody and Ali point because I do think that's the government's, what they're resting their case on here. And it's just very clear. So Olano and the plain error standard is you show an effect on substantial rights by showing a reasonable probability that but for the error, the outcome would have been different. The government is trying to turn this court's cases in Moody and Ali and Hastings from statements about the burden of proof into one of standard of proof. And what I'm saying there is Moody and Ali said, listen, the defendant has the burden of showing prejudice under plain error, and they didn't do so in those cases because all they showed was it was theoretically plausible, right? The jury had these two theories, but they didn't go beyond that and actually demonstrably show it was possible. And that was the problem. So, and I think to show what's happening in Moody and Ali, it helps to think, for example, a tort plaintiff showing negligence. We say they have to show that the defendant was negligent, meaning they exercised care below that a reasonable person would under similar circumstances. When we say that, we're not saying the plaintiff has to show with absolute certainty that the defendant performed below a reasonable person's standard. The standard of proof is one of preponderance of the evidence. So in Moody and Ali, the court's cases were saying, listen, the defendant under plain error has the burden. You have to make a showing, and it's not enough. Our cases have said over and over, it's not enough to show it's theoretically possible. That would essentially be showing something isn't harmless, which that's the standard you get if you preserve the error. But here, we went above and beyond that and showed it was demonstrably possible. And that is because Here, the evidence showed that Mr. Odom may have loaned his cousin the car, and his cousin committed the robbery unknowingly. And so the district court's omission of the mens rea and telling them to use the ordinary everyday meaning of aiding and abetting, which encompasses unwitting help, allowed the jury to convict Mr. Odom based on his theory of the case, his defense.
So let me go back to the Moody argument, because I'm not exactly following what your argument is. Because in Moody, what the court said, right, this is a case about aiding and abetting and principal liability. And the argument was they messed up the aiding and abetting piece, right? And the court says, no, it lays out the standard, but the analysis is there was sufficient evidence to convict Moody as a principal. And the only question was guilty or not guilty. Therefore, Moody cannot establish the jury relied on aiding and abetting to convict him. So we're constrained, therefore, to affirm, right? So the problem is that looks a lot like what we have here, right? So you got a principal and an aiding and abetting theory, right? And this is on the what's in the instruction piece, right? So it's plain error. And so we look at it and we say, is there sufficient evidence to convict him as a principal, right? I'm just literally the words of Moody. Yes, right? I mean, whatever we say, let's hypothesize the answer to that question is yes. And if that's true, and the verdict is a general verdict form, guilty, not guilty, right? Therefore, your client cannot establish, right, that aiding and abetting was used, and so we must affirm, right? I mean, that's literally the language of Moody. And one question is maybe Moody's wrong, but if not, what I don't understand is for this claim, how you can get around what Moody itself does and says.
So 2 points on that. Moody cannot overrule the Supreme Court's jurisprudence on Olano's third prong substantial rights, which they reaffirmed just in Greer as it is a reasonable probability of a different outcome but for the error. So to the extent Moody is saying we don't care if there's a reasonable probability.
It recites that same standard and it says there's no reasonable probability of different outcome where there is sufficient evidence to convict as a principal. I mean, I don't know if that's right or wrong, right? But that's what they are saying, right? I mean, I'm just reading in, that limits us, right? I mean, maybe the en banc court should say, no, that doesn't work. But what I just want to make sure I understand the arguments you have for why your case is somehow different from Moody, right? And if not, that's fine. But I just want to make sure I understand what your arguments are.
Okay, so 2 points on that, Your Honor. And first is I don't read Moody in the way you read Moody, and I think that's because Your Honor is quoting Moody's language, which is quoting the Hastings decision. And Hastings...
It's not quoting anything. I'm reading the last paragraph, which is analysis. It has no case citations, right? Because the case citations come before it. This is the analysis. This is here, right? It's applying the cases, and it's not quoting anything. I mean, this is its analysis.
Okay, Your Honor. Well, that goes to the second point, which is you should not read Moody in that context. And I think it's clear when, in my reply brief, I point to the briefs. The argument that the Moody court was actually presented with was one of, it was just theoretically plausible. All the defendant did in Moody was say, listen, the jury was given principal liability and aiding and abetting liability, but, the aiding and abetting instruction was erroneous. We don't know which one the jury relied on, therefore you have to reverse the convictions. And the court went.
So what's the best support for saying we should narrow Fourth Circuit precedent based on the briefs that were submitted to it? What's the best, where do I go to look to see that instead of taking the language of an opinion, I instead look at the briefs?
Well, there are decisions that say you should read the cases in context and the question presented. So, a question that isn't directly presented should not bind courts later presented and briefed with that precise question. And that is what's happening here, because we briefed. We don't sit on the fact the jury was given two bases. We say, no. Not only was the jury given two bases, one of which was wrongly instructed, but we put up a defense that could have very well resulted in acquittal for a properly instructed jury. Now, if there are no further questions on the aiding and abetting, I would like to turn to the other issues, the first being the denial of the district court's, the denial of our for-cause challenge to juror number 8. And here, if a legitimate question is raised about a veneer person's ability to perform the duties of a juror, the district court has an obligation to affirmatively dispel those doubts before proceeding. That didn't happen here, and thus it was an abuse of discretion for the district court to deny our for-cause challenge and seat juror number 8, who admitted having a hearing issue that resulted in him hearing only, quote, bits and pieces of what the court said.
Were you trial counsel?
I was not, Your Honor.
Were you there?
I was not, Your Honor.
Have you talked to anybody that was there?
I have, Your Honor.
And it took place during the pandemic?
It did, Your Honor.
And tell me about how the courtroom was configured to the extent that you know. See, I think that maybe that had something to do with all this.
Honestly, Your Honor, I don't recall. It's been a while, and I know there was a kind of a mock hearing in our district on how to handle pandemic juries, but I was not present. I think it was only like special invitations, and I did not garner one.
Maybe your colleague on the other side does.
Yeah, maybe he'll be more aware, hopefully. But I will say, notwithstanding the courtroom setup, I think it is probative that juror number 8 was the only person. 29 people were questioned by the court that morning, and juror number 8 was the only one to express any difficulty hearing the district court.
That's not quite right, right? Didn't the district court express difficulty hearing? Didn't the judge say, I too am having trouble hearing in this courtroom?
Yeah, sorry, I meant no other veneer persons expressed any difficulty hearing the court.
And when the judge said, well, when I moved into the microphone, then juror 8 said he could hear better, and that resolved it.
No, Your Honor, the district court never asked the juror anything. When denying our for-cause challenge, the district court just said, I think when I spoke into the microphone, juror number 8 could hear.
Yeah, juror 8 never made any other statement that he couldn't hear something, right? There was one, maybe 2 questions where he said he couldn't hear. The judge said, I moved into the microphone, and I think that solved it. So how do we, sitting here today, disagree with that?
I mean, doesn't the district court have discretion to deal with these things? After all, you and I weren't there. We don't know about your colleague yet. But the district court clearly was.
So 2 points on that. First, I want to address the record and Judge Rushing's point, where, I mean, here, what happened, and it's JA 60 to 62, when juror number 8 was questioned, there were 12 questions limited to the juror's career and family, none about the hearing, and 3 times the juror expressed difficulty hearing the court. Not one question was asked about the juror's hearing impairment. And then second, going to whether or not this court can overturn the district judge when they didn't witness anything.
Well, of course we can. I'm just saying that he was there and we weren't. But let me ask you about the first, as I remember it, you didn't you did not use your for-cause challenges at all, is that correct?
We used our our peremptory challenges, but we did not use a peremptory challenge on juror number 8.
Right. And you didn't bring this up, the defense didn't bring this up later, right?
Well, the defense brought it to the court's attention through our for-cause challenge. So, and at that point, the district court had an obligation before allowing juror number 8 to sit and deny our for-cause challenge to affirmatively dispel any doubts. And that comes from this court's decision in Thompson, where the court was faced with a juror who was giving wavering answers and couldn't confirm being impartial after seeing an upsetting photograph.
You know, I have read all of those cases, and they are cases about the juror and not hearing and whatever, and this just seems to me to be very different, and that's why I'm sort of quizzing you. But I appreciate your answer.
Sure, and it is very different because most of the juror cases admittedly go to bias. It goes to state of mind, and here we have, a potential disability.
Sorry, I want to ask you something about supervised release before you sit down.
Yes.
I have a very specific question, and maybe you can just answer it on when you stand back up. It's fine if you don't know right now. On condition 16 about posing a risk to other people, that the probation officer can require the defendant to notify them, or the probation officer himself can notify them. At the argument, defense counsel referred to the brief and said, I filed a brief that cites all these cases, and for that reason, it's an improper delegation. I didn't find that anywhere in the JA or anywhere on ECF. Can you tell me where that was? Where was this argument made to the district court other than at oral argument?
I will check the joint appendix and let you know during my rebuttal time.
Because what was said at oral argument didn't seem like much at all to give the district court any notice about this argument. But if this written filing is somewhere, then I think that matters. Thanks.
Thank you. I see my time has expired, so thank you very much.
Counsel, we're happy to hear from you. If you know, you ought to start with Judge Rushing's question.
Thank you, Your Honor. The only written document I'm aware of is, I think, document number 45, which is the one in the joint appendix. And
Objections to the PSR, right?
Yeah, and it does not
in there.
contain those cases. It does not contain any cases about the risk notification condition that I'm aware of.
Okay.
And so, to continue on this point, the district court's response to that question was brief, but it was a pure question of law, pure issue of law. It violates Article 3 because it's vague. And the court's response to that was, I acknowledge the question, didn't say much more, but the court didn't need to say more to comply with its obligation to enable effective appellate review and show that it understood the question. It had answered previous questions about delegation, and because it's pure de novo review of an Article 3 question, this court has enough information to decide if there were a substantive reasonableness challenge, to decide whether that violates Article 3. I do want to move on to I'm happy to answer questions about that further, but I'd like to move on to the district court's decision during jury selection. The court acted well within its discretion when it declined to excuse juror 8 for cause. The defendant does have the burden to, through voir dire, establish a disqualification. And I want to make one point here. I don't know exactly how the courtroom was configured. The transcript, I wasn't there either, but the transcript reflects that it was configured for social distancing. I know everybody was spread out and the public was sent to downstairs to watch on TV if they wanted to, so everyone was further apart than they usually are. But a particular feature of this trial was the court allowed the individual parties to question the jurors individually, not propose questions that were filtered, to ask the jurors individually about their experiences, about their partiality. And the defense asked a host of jurors, individually in the group, to the tune of 40 pages. Very pointed questions about their experiences with law enforcement, about their personal biases, about their feelings. Had ample opportunity to ask all the questions it wanted and make any record it needed to establish that the juror was disqualified, and chose not to do so. And that's dispositive under this court's decision in Turner, which holds that when you have a factor that's not per se disqualifying, the court can ask further questions, or the court can leave it to the parties to do that. And if the parties don't follow up, there's no error, no reversible error. Of course, the court also made findings that, you know, and we do defer to the district court because the district court, in the words of, I think it's Hager, the district court's the one on the scene. He understands what's going on. He can observe the demeanor of the defendant. He's the one asking the questions. And he said, you know, I think I could hear him just fine when I spoke into the microphone.
So I understand part of your colleague's argument to be a little bit of language there, right? That the complaint, or part of the complaint the defendant has, is that the judge only said, I think he was able to hear, and that if he had said he was able to hear, that would have been good enough, but the think is the problem. What's your response to that?
I think it would be totally inconsistent with
Think that it would be a response?
I think it would be entirely inconsistent with the deference this court gives to district courts to say that it doesn't get deference because he prefaced it with, I think. It's the district judge's thoughts that count with respect to explaining what it's doing. And in Wainwright, the Supreme Court said, we're not going to put a requirement that the court write a memorandum or explain its reasoning in any detail on this. And in countless cases, this court has said that the deference during jury selection is particularly high. I think what the court said is perfectly sufficient, and even if the court said nothing, the defendant has the burden to establish the disqualifying factor.
Well, maybe I've got another case, but didn't the district court allow the defendant, after they asked some questions, defendant's counsel to ask questions?
I'm sorry, I don't think I heard your question, Your Honor.
Wasn't the defendant's lawyer permitted to ask questions of the jury?
Absolutely, before and after, and of the jurors individually.
Individually, and didn't ask any question about this?
That is correct, Your Honor, not one question about this. You did ask one question. You said this is different from the partiality cases, and I think that's correct. This is not partiality. The Supreme Court has said, as I think my friend has acknowledged, partiality is a matter of state of mind. We don't dispute that a juror can be disqualified if they don't meet the statutory requirements of being capable or not being incapable by reason of mental or physical infirmity to render satisfactory jury service. But it's not partiality. And the reason that's significant is because seating a partial juror establishes prejudice. But seating a juror who's not necessarily partial doesn't necessarily do that. And under Dempsey, which is the 10th Circuit decision that addressed this, there aren't a ton of cases on this, you'd have to show that the seating of the juror affected the fairness of the trial. And I don't think we have any indication of that here. The juror actually was one of the ones who asked the question toward the end of the trial, was very conscientious, and there was nothing in the trial to indicate that there were hearing problems going on. The defense attorney actually said, I'm observing the jurors, and notice some of them might be dozing a bit, but didn't mention anything about juror number 8. And I think that's relevant since we're not talking about a partiality situation. The court also didn't plainly err in a way affecting substantial rights when instructing the jury. Certainly, I think the instruction was appropriate. In order to have an aiding and abetting, you have to have someone commit the principal offense. We have the video that shows.
You say the instruction was appropriate. You mean giving an aiding and abetting instruction would have been appropriate, not that you agree that this instruction was appropriate?
Yes, both of those statements are correct, Your Honor. Giving an aiding and abetting instruction was appropriate because you have to have someone had to have committed the robbery, and the video clearly shows somebody did. You have to have some act, however small, that furthers it, and giving them the car, giving another person the car, something the defense introduced, establishes that element, which is a very, very low bar the Supreme Court has set in Rosemont. And then what establishes his intent to commit his full knowledge of the scope? It's the mask found outside of the Circle K. It's a ski mask in Spring in Gastonia, North Carolina, and it has only Mr. Odom's DNA on it, and that is uncontested.
So I thought you were going to say that those two are important, but that there's also substantial evidence from, for lack of a better term, the jailhouse snitch. Wasn't always in the jail, but the discussions that he had were really what sort of established knowledge and involvement.
Absolutely, that's part of it too, Your Honor. The ski mask I think is important, but the witness also said not only had he talked about doing robberies for small amounts of money, but he had this conversation where he showed an extraordinary interest in finding out exactly when the cashiers at gas stations are checking out, are counting out, and this robbery occurred right when he was counting out. So that is very substantial evidence that.
And then the conversation after the robbery, where he talks about got caught slipping with the DNA in the context of a robbery.
Absolutely, Your Honor, and that is frankly somewhat persuasive testimony because it is so general. If this was a person who was giving us information just to make it up, to help himself, he probably would have been more helpful.
No, we don't need to like put too much weight on jailhouse snitches, but we got to, in this posture, we got to give them full credence. Whether that's the right thing for juries to do is a different question, right?
That's absolutely true, and I think especially when you're talking about is there sufficient evidence to support a jury verdict? If you resolve all the evidence in favor of a Section 2 instruction, certainly there's sufficient evidence to give an instruction. Now, I have no doubt, had anyone asked for it, we would have said the court has to give an instruction about intent. I think the court did get it right in terms of the actus reus, which is aids, abets, counsels, procures. The court said that. The court said you have to find that to find aiding and abetting, so I don't think there's any problem with that. But certainly had someone asked. I think it pushes it a little bit, but it's probably within the realm of plain error because the court didn't misinstruct. The instructions are by definition not an incorrect statement of the law, and all of the law.
You can be incorrect by omission.
Certainly, Your Honor. I just do think there's such a.
If you say you got to prove A, B, and C, and you leave out D, right? That's an incorrect statement of law, right? That like.
Ordinarily, but in this case, D derives from A, B, and C.
Go to your next argument. Assume
Certainly.
it's plain error, and go to the next argument.
Absolutely, Your Honor. I think Moody speaks plainly, and that this court chooses its rule of decision, and that's the rule of decision it chose, but under any standard, however it's formulated. The evidence that the court either, that he was either convicted as a principal, or that he was convicted under the proper understanding, or that is to say, there's no reasonable probability that the result would have been different, either under an aiding and abetting properly instructed theory or under a principle theory, is overwhelming.
Do you think, I mean, is Moody right? I mean, Moody lays out the standard, right? And it says, where there's sufficient evidence that he was guilty as a principal, it matters not that the aiding and abetting piece might have been incorrect, right? That suffices. I mean, that's the full rule of decision. I know this puts you in a difficult position, but we see you a lot, which means that you have a duty of candor that's particularly strong with us. Is Moody right? I mean, it might bind us, but is it really right to say that?
Well, I think the state, I agree with my friend that the correct statement from the Supreme Court is a reasonable probability of a different result. I do think it's a fair thing to say that this is the appropriate implementation of that standard in this case. And I think it's generally correct that when you have two theories and there's sufficient evidence on both, you have at best uncertainty, which this court has long held is insufficient and I think is correct. Uncertainty does not meet the defendant's burden to prove a reasonable probability.
Your point is that there might be, not this case, not Moody, but there might be such a case in which you have alternative theories, evidence sufficient to support one, and yet the verdict can't stand.
Perhaps, Your Honor. It's tough to sort of think through that. I don't think this creates a good example. I don't think Moody creates a good example, and I can't really think of a good example where you have sufficient evidence on one and the defendant can meet its burden to say, well, we're certain. Maybe if you have a special verdict, maybe if there are circumstances.
That's part of the rule in Moody, right? Part of the rule in Moody is that the verdict form only asked whether Moody was guilty or innocent, not which theory the jury relied upon. So that is part of a rule that's inherent in Moody itself.
Yes, Your Honor. And I think I'm trying to answer the question. I'm sounding very wishy-washy, and I apologize for that. But I think Moody is a fair interpretation of the statute. I don't know that it is what, or the standard. I'm not sure that I would be arguing that that is the law if I didn't have Moody. So I'll put it that way, and I hope that answers the court question somewhat. But I really think in this case, either way, the reasonable probability standard isn't there because of that mask. There's just no explanation for why he would have the mask, a ski mask, just outside of a robbery in the very parking lot in which his car was found. If either he wasn't the robber or if he was participating in it in some other way, he either lent his 14-year-old cousin his car or he's there for some reason, if he's not fully knowledgeable, with advanced knowledge of the robbery. It's an overwhelmingly fair inference to say if you have a ski mask on just outside of the robbery and it's got his DNA on it and only his DNA on it, and he discarded it in that parking lot next door, that he was either a robber or an aider and abetter under the proper interpretation of the aiding and abetting theory. So I have a little bit of time. I'll go briefly through supervised release conditions because I think this is a case where the court did exactly what it's obligated to do, which is address all arguments, frivolous and non-frivolous, head on. Condition 8, the defendant shall answer truthfully the conditions asked by the probation officer. The defense said, well, he shouldn't have to, you should put in there that he has to answer, he can refuse to answer on self-incrimination grounds. The court said, entirely reasonably, well, that's already the law. That's correct under Minnesota versus Murphy. And entirely reasonable response. I'm not going to put it in there. Condition 9, the defendant shall live at a place approved by the probation office. The defense said it should be good enough to tell the probation officer, and it delegates too much discretion. The court said the probation officer is there to help you, and people fall among thieves sometimes when they're on supervised release. So I'm going to leave it in there. Entirely reasonable response. Condition 12, the defendant shall not communicate or interact with any people who know to be felons. The defense said there's a dissent, didn't cite the case. There's a dissent by Judge Barrett in the Seventh Circuit saying all felons are not equals. The court said, well, maybe Justice Barrett will convince the Supreme Court, but until then, I'm going to leave it in there. An entirely reasonable response. The defense didn't give the court much to go on, but the court took what he said and addressed it. Condition 16, that's the one we talked about, Your Honor. The court said enough to enable appellate review. Condition 17, the defendant shall refrain from excessive use of alcohol. The court said, the defense said excessive is too fuzzy, too vague. The court said, fine, we'll make it 0.08, and the defense actually acknowledged. Well, that addresses my argument.
No.
Then made another.
Go ahead.
Well, he said that. That gives me very little argument, and then makes a new argument. There shouldn't be any alcohol restriction because he's done well on supervised release. But the court had already said, no, I reject your argument. He'd argued he didn't do anything wrong on supervised release. The jury's verdict was wrong. The court had already rejected that. No, he didn't do well on supervised release. He had a history of using alcohol. He had a history of drug trafficking.
I didn't see the history of using, I'm not sure this matters, but I saw drug use, but not alcohol use talked about.
In the pre-sentence report, he reported social drinking. So.
Well, that's not an abuse. I thought that you originally said it was an abuse of alcohol.
Oh,
So we have an abuse with drug things, but I didn't notice that there was any illegal activity connected with alcohol.
I didn't mean to suggest that, Your Honor. What I'm suggesting is the defendant argued that he had no problems on supervised release whatsoever.
No, I understand that. I totally understand that.
That was the defense argument, and the court
But
responded.
use of alcohol wasn't a problem he had on, so the statement was correct, limited to use of alcohol.
Oh, that's true, Your Honor, but the
Right, but then, and he made that argument, I think, to the district judge, and the district judge said, he made it more specific, the amount of alcohol you can have.
Yes.
And I'm unfortunately not very well, there was a time in my life when I knew how much was legal and how much wasn't and what affected, but
I think,
Those days have come and gone.
I think .08 is fairly typical for driving statutes.
Right.
But the
That's what
original
I think,
complaint
too.
was that it was excessive was too fuzzy, so the court made it specific. Condition 17,
But that wasn't the end of his objection to it.
that wasn't. He said,
That takes care of my specificity argument.
yes, and then he said, well, I think you should get rid of it entirely because he's done well while on, he hasn't had any problems while he's on
But of course,
was on
he had
supervised.
problems,
Yes, he had
but not
problems.
alcohol problems.
That's correct, but the defense didn't say alcohol problems. He said
No,
he's
I
had no
understand
problems.
that, but-
That's
But
That's how I think the court understood it, and I think the court's explanation is reasonable. If this court wanted, if the defense hasn't challenged the substantive reasonableness of any of these, but if the defense had, this court would have more than enough to evaluate that question, and that's the standard. Did the court say enough to enable appellate review?
Is it fair to say, I mean, we think about this from time to time, but do we say in our supervised release cases that what's a reasonable response to a defense argument depends upon the degree and nature of the defense's argument? I mean, if the defense files a brief with citations and arguments, that requires more of a response than a passing reference? I mean, is that an idea that comes through in our supervised release cases?
I don't read them that way, Your Honor. I read them that the court has discretion to do that. Sometimes a short explanation is sufficient. Sometimes it requires something longer, and it depends on the circumstances. The lodestar is always, is it enough information to show that the court considered the argument and enable sufficient appellate review? I think a lot of it you could have a huge stack of cases about whether something violates the Constitution. But the court wouldn't have to say much because, well, I don't think it violates the Constitution, would enable this court to de novo consider whether it violates the Constitution.
yeah, I think this, and you help me here, this seemed to be a more thorough review of conditions of supervised release than I've ever seen.
It's very thorough, Your Honor, and the court entertained.
Addressed every single one of them, and
I absolutely think so, Your Honor, and the court tried, I think, to address everything, including things that are kind of difficult to understand when faced with that. And it's worth considering. This is a district court on the bench having to deal with this ad hoc. These are arguments the court, some of which there's very little in that brief that the defense filed. Most of these arguments are brand new. They rely on cases, an uncited dissent in the Seventh Circuit. I think the court did a pretty good job of responding to some of these. Same thing with the last one, which is, shall participate in a program of testing for substance abuse. Here's another one where the defense kept modifying its argument in response to things the court said. This court has emphasized it's not a game of gotcha, but the court responded to each part of that. The court didn't misunderstand. The court didn't think it was about testing. I see my time is up. I'm happy to continue, but I'm also,
no, I'm fine.
okay, I will rest on my briefs and ask that this court affirm the judgment of the district court. Thank you, Your Honor.
Thank you so much, counsel. Counsel, you got a few minutes?
Thank you, Your Honors. So just going to Judge Rushing, I looked back. The only thing the defense submitted prior to the sentencing hearing is 740, 745 with the objections. There were no cases on the vagueness. There was a kind of catch-all objection, including number 12, citing an improper delegation at 745. And then I will say,
I asked that just because the counsel didn't really state why it's vague, right? And so the district court wasn't really presented with an argument that it's vague to give this this is an improper delegation because X. So not to fault counsel for, saying there were cases when he didn't actually cite the cases. You cited cases to us, but I just wanted to understand what was in front of the district court. So thank you for that.
Yes, you're welcome. And then, so just, supervised release conditions were an issue in the Western District for a while, and it actually culminated, I cited in my reply brief, a revised standing order issued about 6 months after the sentencing, where 4 of the 6 conditions we objected to were actually removed or materially amended to address our objections. And so that was 16, 8, 9, and 7. So the only 2 that remain are the condition 12, interacting with felons, and number 17 on excessive use of alcohol. So, And just going back, I think, this court's case law is you have to address the central thesis of the defendant's objections. And here that wasn't done. As Judge Motz pointed out with the alcohol restriction, we pointed to the lack of history using it. And so the district court really didn't answer that question. And even now, my friend struggles to address why it's necessary, given the fact all we know is, he has a beer sometimes at football games. He's a social drinker. Now I want to go back to kind of the heart.
To be clear, you haven't challenged whether it's necessary for him or not in this appeal, right? You didn't bring a substantive reasonableness challenge.
No,
You've just challenged the district court's explanation about whether it heard and how it responded.
Yes, the district court's explanation arguing it wasn't reasonably related to this defendant. So now I'd like to go and address the aiding and abetting instruction. And here, the government refuses to defend Moody's standard, and they fall back on the Supreme Court standard, a reasonable probability of a different outcome. And instead, they argue, this court should.
I understand you want to denigrate your colleague, but I don't think he refused to defend Moody at all, right? He talked about that maybe there are exceptions that exist, but to say he refused to defend Moody, I think is an unfair characterization of what your colleague said and what I asked.
Okay, so maybe it's because I was going to go on, and maybe this would help clarify it, but argued that Moody correctly implemented the standard, and that implementation here is a bright line rule that whenever two theories of liability are given, an instructional error on one will defeat any plain error. So essentially here what we have is, the Lockhart in a different setting, right? So here you're essentially saying there can be no plain error when the government presents two theories of liability. Because to get there, you'd have to say that, so in this case, there'd have to be insufficient evidence for principal liability. So we don't have to just show a reasonable probability the jury convicted based on the misinstruction. We have to show absolute certainty, because it is only if we can show that there was insufficient evidence for the principal liability, the only basis of liability the jury was correctly instructed on, could we prevail. And that is not the standard. And here it was especially harmful. The jury was given evidence from which they could conclude that Mr. Odom unwittingly assisted. And I see my time's expired, but I'd just like to briefly address some of the factual points that Judge Rushing actually relied on when questioning Mr. Anwright.
Sure.
So just
Briefly,
just on the ski mask, if it was Mr. Odom's car that his cousin used, the ski mask could have fallen out. I keep an ice scraper. I'm from New England. I keep an ice scraper in my car year round. It's going to be in there June, just to be in there in February. And then second, I want to go to the Mr. Davidson's testimony. And so just to be clear, the government points to its generalized nature, but here we have sometime in 2017 or 2018. So these statements, him asking a gas station worker, could have been made 14 months before the robbery or after the robbery. And then second, with the comment about him getting picked up on robberies and caught slipping on DNA. Well, the DNA swab wasn't even taken until November 20th, and it wasn't even put in a request for forensic testing until 2019, and Mr. Davidson testified that the statements came in 2018. So we would just say this was definitely a question for the jury, and the misinstruction deprived the jury of making that determination of Mr. Odom's guilt, and we would ask this court to reverse the convictions. If there are no further questions, thank you very much.
Thank you, counsel. We'll be happy to come down and greet, and then we'll take a very short recess before heading to our third case.
This honorable court will take a brief recess.
Thank you very much.
Much better. Yes.
Thank you very much.
Right back here.
Thanks. Probably, yeah. You're here all week, aren't you?
Happy to move to our third case of the day, 22-1927, Thane versus Crouch. Counsel, we're happy to hear from you.
Thank you, Your Honor, and may it please the court. My name is Caleb David, and I represent the appellants, defendants below, who are state officials that oversee West Virginia's Medicaid program, as well as the state agency that administers that program. West Virginia Medicaid provides health insurance coverage for individuals in low-income households, as well as for individuals whose medical conditions render them effectively needy. The goal of West Virginia Medicaid, like all health plans, is to provide the most benefit to the largest number of people with their limited resources. And Medicaid provides those services equally to all of its beneficiaries. There is no service that is covered for a cisgender person that is not covered for a transgender person meeting the same criteria. The plaintiffs in this case have not been denied any services on the basis of a transgender identity. Shantae Anderson receives gender-confirming hormones through Medicaid. Medicaid pays for her office visits related to those hormones, and Medicaid pays also for her lab work, her psychological and psychiatric care related to gender dysphoria. Christopher Fain also receives gender-confirming hormones. Medicaid pays for those as well as for his office visits related to receiving those hormones. Both Ms. Anderson and Mr. Fain testified that they have never been denied coverage for any service on the basis of their transgender identities. This case is solely about whether West Virginia Medicaid runs afoul of the Equal Protection Clause, the Affordable Care Act, and the Medicaid Act because it does not provide insurance coverage for gender-affirming surgeries. It does not violate any of those constitutional or statutory provisions. The Supreme Court in Alexander versus Choate held that Medicaid programs do not guarantee that each recipient will receive that level of health care precisely tailored to his or her medical needs. Instead, the benefit of Medicaid is the individual services that are provided. And that basket of services that Medicaid provides is provided to every single beneficiary equally.
Okay, can I ask you a question that is the simplest question I can think about factually on the ground about this? So does the Medicaid pay for hysterectomies
Yes, Your Honor.
and transgender people wishing to have hysterectomies?
Yes, Your Honor. West Virginia Medicaid has provided a hysterectomy, coverage for a hysterectomy to Christopher Fain. The plaintiff in this case received a hysterectomy for something that was not related to gender dysphoria. And
No. If you have gender dysphoria and you want a hysterectomy for that, it's been diagnosed, will Medicaid pay for a hysterectomy?
For the treatment of gender dysphoria
Correct.
solely? No, Your Honor. That is what the
But that
case is
seems to
about.
me to be a procedure that is provided to cis people, right?
Yes, Your Honor, and it's also
And I thought you
provided-
told me that all the procedures that were approved for one were approved for the other.
Yes, Your Honor, and they are.
But they're not, you just told me they weren't provided to transgender people to cure. So you're now looking at the effect, but not the procedure. The procedure's the same.
Your Honor, the facts of the case are that the procedures are not the same.
They're not the same.
Yes, Your Honor.
And if they are the same, if medical studies said that they were the same, for a different purpose, you would provide it to transgender people. Is that correct?
No, Your Honor. The
Then it doesn't make any difference to you whether they're the same or not, right?
It does under certain circumstances and certain claims that are raised, but not under the equal protection argument.
Correct.
And, Your Honor, under the equal protection argument, what we provide, and the ruling of Godaldig is that you have to provide equal services to people similarly situated. And in this instance, Christopher Fain had a hysterectomy for something that's unrelated to gender dysphoria.
And we're talking about the transgender person you think is not similarly situated to the cis person. Is that correct?
Yes, Your Honor, because they have to meet the same medical criteria. So, and this isn't for Mr. Fain, and for reasons of confidentiality, I'm not going to say what the reasons were for that Mr. Fain received a hysterectomy, but for instance, the Medicaid plan provides for hysterectomy to treat endometrial cancer.
Well, they have the same current procedural terminology code.
The same CPT code? Yes, in certain circumstances, the CPT codes are the same. Yes, Your Honor.
Into the easy example I'm giving you. So that's a certain circumstance we're talking about.
Yes, Your Honor. The same CPT code would apply for billing purposes.
And they're industry-wide, used by health care providers,
Yes, Your Honor.
insurers. And we should ignore that then?
No, Your Honor. The analysis is whether or not someone who's meeting the same criteria is not going to be provided that on the basis of their transgender
I
identity.
know, but doesn't CPT code tell us about whether you meet the same criteria?
No, Your Honor, that's a
No.
billing service. There are different guidelines that the parties have both put in that are in the joint appendix that we call interqual guidelines. And interqual is a nationally recognized company that provides coverage guidelines for certain procedures. And in this instance, they have a separate set of guidelines for gender affirmation surgeries like those that are at issue here than they do for hysterectomy, for instance, for oncological care. Those are separate guidelines, and there are separate criteria that the individuals have to meet to qualify under those guidelines.
So I just want to be sure I understand what you're saying. So is there a policy that I can look to that says that transsexual surgery is excluded?
Yes, Your Honor, it's under the list of non-covered services
So
in the Medicaid plan.
how can that not be discriminatory under this court's precedence about the rights of transsexual folks?
Yes, Your Honor. So under Godaldig, the analysis is looking at whether or not there are bright lines that are saying that, and in Godaldig, it was pregnancy. There was a disability insurance program in California that excluded coverage for disabilities related to pregnancy. And of course, that only affects women. And the court said, when you look at it and you actually look at the analysis, on one side, you have women who are pregnant. On the other side, you have all other persons, and that includes both women who are not pregnant and men. And because there are members of the class on either side of that line, and because the actuarial benefits of the program not covering disability benefits for pregnancy accrue to all of the members of the program equally, then that's not a gender-based or a sex-based classification. And we have the same situation here. And it's important to understand that there is a distinction between someone having a transgender identity and someone having gender dysphoria. And everyone agrees that in this case, and it's undisputed in the record, that being transgender or
There's
having
another distinction between someone who has just gender dysphoria and someone who wishes to have what West Virginia terms transsexual surgery.
Yes, Your Honor. So the testimony in the record is that 1 in every 200 individuals has a transgender identity, but 1 in 1,000 are in clinical care for gender dysphoria. And an even smaller number that's undefined, but a smaller fraction of those 1 in 1,000 are seeking gender-affirming surgeries. So applying the holding in Godaldig here, you have to look at the class. So the class in this instance is transgender individuals.
So I'm sorry, I guess I'm not following. If this person was both a transgender person and had gender dysphoria, there would be a different result here?
No, Your Honor.
I didn't think so.
The only individuals who are seeking these services.
No, I'm not talking about this case. I'm talking about another case when the person is both transgender and has gender dysphoria. Or wants transgender surgery and has gender dysphoria. That is not this case, right?
That is this case, Your Honor.
Okay.
The plaintiffs are both transgender individuals. They have testified, and there's evidence in the record that they have gender dysphoria, and they are seeking surgery to treat their gender dysphoria. So
what was different in my colleague's hypothetical to you?
Your Honor, the analysis under the Equal Protection Clause, as the Supreme Court held in Gedaldig and recently reaffirmed in Dobbs, is that you can't add on to a class. You can't append on to a class. Once you do that, then it's no longer discrimination against a class. And in Bray versus Alexandria Women's Health Center, the Supreme Court looked at abortion, and they specifically said women who are seeking abortion are not a class. Women are a class, but women who are seeking abortion are not a class. And in this instance, transgender individuals are a class, but transgender individuals who have gender dysphoria and who are seeking gender-affirming surgeries is not a class. That's not a sex-based classification, and so rational basis review applies. And the Supreme Court has held in Gedaldig and in other cases that the actuarial benefits and those cost analyses are sufficient to survive rational basis review when looking at these benefits programs like the disability program in Gedaldig and the Medicaid program here in this case. And, Your Honor, the issue on, excuse me, on equal protection grounds doesn't simply end at that argument. The plaintiffs can also prove that that this is a proxy, that there is invidious discrimination that's occurring here, and that transsexual surgery is simply a proxy for the actual invidious discrimination, the discriminatory motive of the Medicaid program to target transgender individuals. And we moved for summary judgment on this issue because there's simply no evidence in the case to suggest that. First, as I stated at the beginning, West Virginia Medicaid does provide coverage for gender-confirming care up to, but not including, transsexual surgery, as it's termed, or now it's called gender-affirming surgery. And because we provide psychiatric diagnostic evaluation, psychotherapy, psychological evaluation, counseling, office visits, hormones, and lab work, there's no evidence that there's invidious discrimination here. And specifically, the testimony in the record from the Medicaid programs 30B, one of the Medicaid programs 30B6 representatives, was that they decided in 2017 to cover hormone therapy and psychological counseling for individuals suffering from gender dysphoria, specifically because they had heard stories about individuals being distraught that they could not receive hormone therapy when they were experiencing gender dysphoria. That came from a place of trying to help those individuals. And unfortunately, West Virginia Medicaid cannot provide coverage for everyone tailored to their specific needs, as the court found in Alexander versus Choate. It doesn't have to be tailored to their specific needs, and unfortunately, the reality of the situation is that there are limited resources, and someone may have an issue, and West Virginia Medicaid cannot provide coverage for everyone to have what the court called adequate health care. The actual benefits are the basket of services that are being provided to those individuals. And the Supreme Court held in Dandridge versus Williams and reaffirmed in Gedaldig that the Equal Protection Clause does not require a state to choose between attacking every aspect of a problem or not attacking the problem at all. And the Supreme Court has also held in Williamson versus Lee Optical and in Jefferson versus Hackney that a state may take one step at a time, addressing itself to the phase of the problem which seems most acute to the legislative mind. The legislature may select one phase of one field and apply a remedy there, neglecting the others. That's exactly what West Virginia Medicaid has done in this situation. They have provided care for certain aspects of gender dysphoria. They have not provided care for gender-affirming surgeries, and they are permitted to do that under the Equal Protection Clause. They're also permitted to do that under the Affordable Care Act. The analysis is essentially the same under the Affordable Care Act. You cannot discriminate on the basis of sex. For the same reasons under Gedaldig that this isn't a sex-based classification for equal protection purposes, it's also not a sex-based classification for purposes of the Affordable Care Act. And lastly, on the Medicaid Act, there's nothing in the Medicaid Act that specifically requires any program to provide these services. And in fact, since 2004, which is the earliest point in time that we can find West Virginia Medicaid policy that specifically lists, among other non-covered services, transsexual services. So for the last 20 years, CMS has annually approved the Medicaid plan that West Virginia has put before it. And for those reasons, it also doesn't discriminate or doesn't violate the Medicaid Act. My time is up.
Can I ask just one question before you go? You have not argued that there's no cause of action under the Medicaid Act, have you?
We have not taken that position, Your Honor.
Thank you. We'll hear from you again in a few minutes. Counsel, we're happy to hear from you.
Thank you. May it please the court. Tara Borelli with Lambda Legal on behalf of the plaintiffs' appellees. I want to return to something that my colleague said a moment ago, the testimony of a witness in the case who said, we learned that transgender people who were being denied hormones were distraught over that denial. And so we decided to provide that care. It's medically necessary, along with all the other care that they provide for transgender people. And so this is a story of kindness and compassion. That was his testimony. And he was asked at deposition, why doesn't that kindness and compassion extend to surgery? And he said, I don't know. I don't know the answer to that. And that's the story of this exclusion. It's a government classification in search of a justification. They don't know when they adopted this exclusion. They don't know why they adopted this exclusion. They've performed zero research or analysis about it since that time. And they stipulated that nobody who either adopted or who maintained the exclusion has ever conducted any research or revisited it or considered a scrap of paper. I want to turn to a couple of points that my colleague raised. With respect to the fact that Medicaid covers a range of other services, office visits, lab work, hormones, for example, that just points to the arbitrariness of the blanket and categorical ban on surgery. And I want to be very...
I want to make sure, because there's a little confusion in your briefing as to what you keep referring to the exclusion, but I want to understand what you say it is. So you describe it on page 3 of your brief as an express exclusion of surgery for transsexual people, and I know transsexual is in quotes, but we're going to use the language that West Virginia's used. I mean no disrespect in using that over transgender, but as you do for transgender people facing facially discriminates, right? That's the argument. And what I'm having a little trouble with is here and elsewhere in the brief, you suggest that there's an exclusion of surgery for transsexual people. But when I look at the policy, it doesn't apply to transsexual people, right? Transsexual is an adjective that describes the type of surgery, right? Not the people for whom it applies, right? And so I just want to make sure I understand, you're not arguing or claiming that this is a ban on all surgery for transsexual people, which is what it says, exclude surgery for transsexual people is how you describe it. But that's not accurate, right?
So I appreciate the chance to clarify. So the ban, I think the wording of the ban, the exclusion is very important because it doesn't name a single procedure, but it names the group targeted and singled out for discrimination. So one piece of
why?
it.
That's what I'm having a little hard time understanding that because you say it is a exclusion of surgery for transsexual people. But presumably if a transsexual person has a heart problem, they can have open heart surgery, right?
Yes.
And if a trans person has any other problem that requires surgery, they can have that surgery just like Thane did here. Right?
Yes. So to be clear, let me talk first about what it says and then what it means. What the exclusion says is no coverage for, quote, transsexual surgery. That doesn't actually name a single procedure. It just names the group.
Just so I understand, that adjective transsexual is describing surgery, not a group of people.
It describes the person. It doesn't name a single surgery.
I think your argument turns on this, so I want to be sure I understand it, right?
Yes.
So how, when I read the word transsexual surgery, do I interpret the word transsexual as anything other than an adjective describing the noun that follows it, surgery?
Because a few reasons. First of all, the surgery is the same. And so this, when it says...
Same as what?
The same as the
Same
care...
as being transsexual?
No, the same as the care provided to cisgender people. So a hysterectomy, an oophorectomy, a vaginoplasty, the unrebutted testimony...
Answer the question of why the adjective... I'm literally asking like a linguistic question, right? The ban on transsexual service or transsexual surgery. You want to read the word transsexual as an adjective describing person, or perhaps to describe it as a noun, right? But the words are transsexual services. So transsexual is an adjective describing the noun surgery. It is a type of surgery. Whatever that type is matters not for this point, right? But do you understand what I'm saying? You keep saying it's about transsexual people, but the ban doesn't say transsexual people. It says transsexual surgery, which is a type of surgery.
So let me be clear. The other piece of the ban refers to sex change surgery. That might be another way of understanding what this exclusion does. It doesn't
That is a
exclude.
type of surgery, right?
No, the testimony in the record by Dr. Schechter, the only surgeon to testify, is that every surgery that a transgender person seeks is the same as the surgery that a cisgender person seeks. The surgeries are the same. Defendants left that testimony completely unrebutted. This is an expert surgeon who's performed hundreds of gender-affirming surgeries. The hysterectomy is the same. The vaginoplasty is the same. All the surgeries are the same. What this exclusion does is says this group of people, transsexual people, you are the people who cannot get that surgery if you need it for gender-affirming care. If cisgender people require it for other reasons, they can have it. But if you need it for gender-affirming care, you cannot have this surgery. And this court has spoken to that.
Can I ask about that? I don't want to take us too far afield from the linguistic question, but I thought we have to look at the policy as a whole, right? So we have, as you mentioned, we have the what they call transsexual surgery. There's sex change, it's referred to. West Virginia says we don't cover any surgery that's the diagnosis is what they call a psychiatric condition. So they say if it's a DSMV diagnosis, then we don't cover surgery for that. We don't cover physical surgery for diagnosed mental conditions. And I understand you disagree with that categorization. But I had a question about your expert, Dr. Olson Kennedy. And Dr. Olson Kennedy testified that cisgender people can also sometimes feel as though their body doesn't conform to their expectations for their gender. And Dr. Olson Kennedy testified that if a cisgender woman had hypomastia, that Dr. Olson Kennedy would refer that person for surgery for breast augmentation if it caused the cisgender woman distress, significant distress. And West Virginia's answer is, we wouldn't cover that. It's not because she's cisgender, it's not because she's not transgender. We don't cover that surgery for that diagnosis. So how does that evidence support, from your expert, support the conclusion that we're talking about the people rather than the procedure and the diagnosis?
So I think I hear at least two questions. Let me take them in turn. The first one is in terms of their argument that they don't cover diagnoses in the DSM, the unrebutted testimony in the record is also that gender dysphoria also consists of a medical condition. It is widely.
And so that, as I said, I know that you categorize it not just as a DSM, but also a medical condition, and that might dispute how you might think West Virginia misunderstands, right? They misunderstand the condition, but I'm just trying to understand the classification that they're drawing, right, for equal protection purposes.
Correct. And an additional important piece of evidence in the record are the interqual guidelines. So these are the guidelines for medical necessity that the West Virginia Medicaid program uses, their own medical necessity guidelines. And those guidelines recognize that treatment for gender dysphoria, including surgical treatment, is medically necessary. The only thing that bars those guidelines from being used to provide medically necessary care.
Again, that goes to whether they have a rational basis or whether they satisfy strict scrutiny, but my question is just about the classification. If West Virginia says we don't cover this surgery based on what we consider a psychiatric diagnosis for anyone, how do I reconcile that evidence with your theory that they are drawing a classification based on a person's transgender identity?
Here's a next important piece that I want to make sure I've mentioned. On the face of any
Talk just a little louder.
Yes, Your Honor, I
Getting
apologize.
softer and softer.
Oh, I apologize, Your Honor. Thank you.
We all have sometimes trouble hearing.
Understood. So in the interqual policy, if you look at the face of every single policy, it contains ICD codes. These are International Classification of Diseases codes promulgated by the World Health Organization. Again, a classification system for diseases. That's what interqual relies on. Gender dysphoria is in that listing as a disease under the rubric of gender incongruence. By every metric that this program uses to measure what is a medical condition, gender dysphoria satisfies that metric.
But you're just going back again to disputing, you're saying West Virginia misunderstands the diagnosis, right? And if they understood it properly, they would cover this. But that doesn't answer my question about how does this prove they're drawing a classification based on a person's sexual identity rather than based on the surgery and the diagnosis?
Because the surgery is the same. So, for example, Christopher Fain required a hysterectomy. It was performed to treat a different condition. But if he needed that for treatment for gender dysphoria, it would be absolutely barred. And this court...
Well, that's my point. The procedure, it may be the same. Now, they dispute that, but it would be the same for a cisgender woman who has hypomastia, and it causes her severe distress, and she wants surgery. But West Virginia says, we won't cover that. We don't care if you're cisgender. We don't cover that for that diagnosis.
Right. So a cisgender woman is never going to be diagnosed with gender dysphoria. And this was not disputed anywhere on the record. Only transgender people have
But it was your doctor, Dr. Olson Kennedy, whose testimony I'm talking about here. And I'll let you go and move on to other things. I thought this was a real sticking point for your argument that appears multiple times in your brief, that we can equate the surgery with the identity because this only ever comes up for this person, but your expert said that's not the case, that she would recommend surgery in the other context.
So she did not testify, to my recollection, at all that would be for gender dysphoria. There are a range of surgeries that a person might want or might need. Though they can be cosmetic, what this case is about is only care for gender dysphoria. And this court has already recognized the close relationship that only transgender people are diagnosed with gender dysphoria. And the court said in Williams versus Kincaid, as a matter of constitutional avoidance, if a law excluded gender dysphoria from its protection, we would have little trouble concluding that that discriminates against transgender people as a class. And again, one only needs to look at the face of the exclusion itself.
What
Transsexual.
about people who suffer from gender dysphoria and want surgery? You agree that's a much smaller percentage of the protected class?
So those are all transgender people, and there's no requirement under equal protection that every single member of a class be affected in order for there to be an invidious distinction. That's Rice versus Caetano, Nyquist versus Moclay, and this court's own decision in the Peltier case, where not all parents and not all students objected to the requirement that female students wear skirts, and the court said some parents can't nullify the constitutional rights of others. So there's never been a requirement that every person, every member of a group be affected. But here, only transgender people are affected. And for those who are Medicaid participants, they face an absolute categorical bar on this care. Let's see, I also want to just jump a little bit to the Geduldig point. This case doesn't resemble Geduldig. This exclusion is completely different from Geduldig. It might be the same if the plan said no one receives coverage for a hysterectomy. That was what happened in Geduldig. Nobody received benefits for pregnancy, disability benefits for pregnancy, and that mattered to the court. The court said there's no risk from which men are protected and women are not, or from which women are protected and men are not. There was no differential treatment. Here, there's clear unrebutted differential treatment. At JA 304, there's a long list of surgical procedures. Those are the very same surgeries that transsexual people require to cover, to treat gender dysphoria, and they're absolutely denied under this exclusion. So there's a clear demarcation and difference from Geduldig. There was no differential treatment there. Here, the differential treatment is undisputed. Additionally...
Can I ask a slightly different question? And that's sort of to go a little bit to sort of the Bostock analysis of sort of but-for cause. And so help me understand, if Fain was a biological male or cis, whether we're talking about sex or transgender, but I'll use male. The analysis works, I think, the same with transgender. But if Fain was a biological male, then West Virginia would not provide coverage for a mastectomy, right?
Sorry, meaning he's a cisgender man?
If I only change that fact, right? So
They do cover that. They cover it for gynecomastia. So if cisgender...
No, but I'm gonna only change one thing, right? So the point of Bostock, right, is you change one thing. And the only thing I change about Thane is that biological maleness, right? But otherwise, everything else remains the same. No additional diseases or cancers or anything else. But the only thing I change is biological sex from female to male. In that scenario, West Virginia would not give Thane mastectomy.
Not true.
Why? That's what I'm
And that's a
understand. That's what I
perfect
wanna
example,
understand.
Your Honor. It's a perfect example because if Mr. Fain's sex assigned at birth were male and he had excess chest tissue, which generally is diagnosed as gynecomastia, West Virginia would cover that.
If okay, totally fair,
And it
right?
has to be symptomatic.
The key phrase there, though, the key phrase you just added was a different condition, right? So if he had gynecomastia, I don't know what that is, but I'll assume that's a different condition, right? If he had cancer, if he had something else, that's fine, but then you're changing two facts, not one. Do you still understand what I'm saying?
I do understand what you're saying.
This is the Bostock analysis, right? Bostock tells us you change only one thing, not two things, right? You don't get to change their sex or gender and their, sexual preferences, right? You just change one thing, right?
Yes.
Transgender, now cis, and
Yes.
doesn't get the mastectomy.
He does. If he has access, there would be a diagnosis for that.
If what?
And
If he
if he
has
has-
a different diagnosis.
If he is a male with excess chest tissue, and everybody has to have a diagnosis to get treatment, so that's the same. That's the same. If he's a male with
The
excess...
diagnosis changes, though. In your hypothetical, the diagnosis has changed, right?
Right, but if you look at the diagnosis here, so this can be analyzed as a matter of discriminates based on sex assigned at birth, discriminates based on diagnosis, discriminates based on both, or you can look at either in isolation. They all point to sex and transgender status discrimination. Williams v. Kincaid recognizes that gender dysphoria discriminates against transgender people as a class. That's the language of that decision. And the exclusion here also is about sex change surgery, and that on its face says, we disapprove of this sex-based purpose. If you're doing something that doesn't align with your sex assigned at birth, we disapprove, we will not cover it. That is sex discrimination.
Thank you, counsel. I
Thank-
believe your colleague has a few minutes.
Yes, thank you very much.
Thank you.
May it please the court.
Counsel.
My name is Anna Prakash, and I represent Christopher Fain, Shantae Anderson, and the certified Rule 23 class. The district court did not abuse its discretion in finding numerosity here, and that's because the court recognized that what this case seeks is not a declaration that all transgender folks on Medicaid are automatically entitled to surgery. Rather, the district court recognized that this case is about lifting the bar that prevents transgender Medicaid participants from even being considered for surgery. As the district court explained, and this is, I believe, in the summary judgment opinion, talking about standing, the state has constructed a barrier, a discriminatory barrier, between every trans person and health insurance coverage for the surgical care that you all have been talking about this morning. So because of that, the existence of the 686 folks that the parties have gone back and forth in their briefs about, because of that, their existence proves numerosity, because each and every one of those folks is a transgender Medicaid participant, and even just a fraction of those, if even just a fraction of those folks were to seek surgery, we would be at this 40-person numerical threshold that the Fourth Circuit has adopted. Now, the state goes on about ascertainability. Ascertainability in the context of a Rule 23b2 class is not technically required. This circuit has acknowledged in the Thorne case that we're talking about a class that is purely for injunctive relief, and that it is different than a Rule 23b3 class where notice is required and the opportunity to opt out is given. That is not this case. This case is about injunctive relief on behalf of every single person. And for those reasons, unless the court has further questions, I will rest on our briefs and ask that you affirm.
Thank you, counsel. Counsel, we're happy to hear from you.
Thank you, Your Honor. And I'd like to start back at that linguistic question that you had. Transsexual surgery is simply a description of a group of procedures, the same way that gender-affirming surgery is a description of a group of procedures. It's not, you don't say, I need gender-affirming surgery. It's not specific enough. It's, I need a mastectomy to treat my gender dysphoria. That is a specific procedure. It's not describing an individual, it's describing a group of procedures. And actually, Dr. Schechter, the plaintiff's expert, testified that gender-confirming surgeries are typically a constellation of procedures that include top surgery, genital surgeries, and also potentially hysterectomy, oophorectomy, orchiectomy. And I also want to touch on the point that these are not the same procedures. And again, they are under different criteria. You must meet different medical criteria and different guidelines to qualify for these procedures. But Dr. Schechter described in his deposition what's involved in vaginoplasty for a gender-affirming surgery. And that includes removal of the penis and testicles, followed by use of tissue from the penis to construct a vaginal canal, labia, and clitoris. Those are not the same. That's not the same surgery as one that is done for someone who has a congenital absence of a vagina, because there's no penis, there are no testicles. That's not something that's being removed and healthy tissue being extracted from someone's body and being used for a different purpose. Those are different procedures. Now, I also want to touch on this issue of medical necessity. And there is testimony in the record from our own expert who disputes the medical necessity of these surgeries. However, Medicaid is not required to cover all medically necessary care and doesn't cover all medically necessary care. For instance, temporomandibular joint disease, TMJ, issues with the jaw, that's a medically necessary surgery, and that is a surgery that Medicaid does not cover. We specifically have among that list of non-covered services that includes transsexual surgery, we also have TMJ. We also do not cover inpatient psychiatric services for individuals between the ages of 22 and 65. There's no question that some people may need inpatient psychiatric services between those ages, but we do not provide those services because of cost. And it's the same issue here. There was a statement that a 30B representative was asked about why we determined that we were going to start covering hormone therapy and counseling, and that it was done because there were individuals who were distraught, and it did come from a place of caring and trying to help them. There's a different person who answered the question of why, and that person explained that in 2024, West Virginia Medicaid will have a $128 million deficit. If that is not cured by the legislature, in 2025 they will have a $256 million deficit. And that's going to continue to grow unless the legislature provides funds. We don't know if the legislature will provide funds. We have requested funds for other care in the past and been denied. Last legislative session, we were denied twice in asking for modest increases in our appropriations. We can't guarantee that those services will be there. So we would have to make decisions as to what we're going to cut, because there are a set of required services that Medicaid has to cover, and then there are optional services. This would be an optional service, and Medicaid would have to determine what the proper mix of amount, scope, and duration limitations are for other services. So they would have to reduce the benefits, and that is the actuarial issue that we're talking about and what Gedaldig makes so important. I also want to touch on this issue that there is this invidious discrimination because of the words transsexual appear in there. West Virginia Medicaid does not track gender identity. They have no way of knowing whether someone is transgender or not. It's not something that they look at. It's not something that they track. Their system doesn't designate it. So there is nothing that is covered for a cisgender person that's not covered for a transgender person. And case in point is Mr. Fain's hysterectomy that he received. He received that because it wasn't for gender dysphoria. And we can see that if it was for gender dysphoria, he wouldn't have received it. But that is the one thing that actually changes this, is the diagnosis and what the treatment was for. It does not matter that he's transgender, just like it doesn't matter if someone is cisgender, just like it doesn't matter if someone is a man or a woman. For all those reasons, I see that I'm out of time, and I ask that the court reverse.
Thank you, counsel. As you heard, we get to come down and greet you again, so we'll do just that.
Justification for a return of that money, no matter the legal justification, the ensuing obligation is not dischargeable in bankruptcy pursuant to Section 523A2 of the Bankruptcy Code. Before I delve into the bankruptcy idiosyncrasies, though, I want to touch upon the jurisdictional inquiry. We obviously received the request for supplemental briefing, and we obviously appreciate that the court needs to be assured of its jurisdiction before it can touch upon the merits of the appeal. I believe the court has proper appellate jurisdiction, as did the U.S. District Court for the Eastern District of Virginia, for the simple reason that there is a final order in this case, and that there is no separate rationale to deny the court of that jurisdiction. And I'll point to the two cases that were chiefly noted in the order for supplemental briefing. Starting with the Supreme Court's opinion in Microsoft. The most critical part of that case in analyzing this case isn't the majority opinion, which delves into the idiosyncrasies of class certification and what happens when one wishes to appeal a denial of class certification, but rather the concurrence. Justice Thomas, joined by Chief Justice Roberts and Justice Alito, notes that there's nothing about Rule 23 that governs what is or is not a final order. Very familiarly, you have a final order when there's nothing left for the trial court to do. And looking at the facts of this case, there's no question but that there was nothing left for the bankruptcy court to do in the prism of the adversary proceeding. Once the first count was dismissed by the court and the second count was dismissed.
But the rub there is, right, that there was nothing left to do, but only because you manipulated the system. I don't mean that in a bad way. Some people use the word manipulation. I don't mean that this is not a disparagement, right? But Microsoft says you don't get to manipulate the system to sort of put a claim on hold, subject to reopening it, in order to get your appeal, right? And that looks precisely like what was done here. I don't mean to say you, but what was done.
Your Honor, it was me.
Yeah,
I will
I know.
take full, I called up Mr. Fasano, we struck a deal, and that was that.
Yep.
We were trial counsel, not that there was a trial.
Right.
No.
I will say this, I don't think manipulating the system, and I'll use that verbiage, in this case is a bad thing for three reasons. One, the case was moot. There was actually an absence of subject matter jurisdiction once the district
I don't follow that. I know you said that in your briefs, and so maybe you can explain it in a way that's different than you explained in your brief, because I thought this is a case, it turns out there are assets. The trustee was wrong. It's not a no-asset case. It is an asset case. And if I understand that you'd rather it not be dischargeable, but how does the fact that it's dischargeable moot the claim for the money?
Yes, Your Honor. This is a bankruptcy quirk that admittedly stretches the imagination and for which I fully blame Congress. In the rest of the known universe, or at least the United States, a claim is established by obtaining a monetary judgment and going to collect thereupon. In the bankruptcy world, pursuant to Federal Rule of Bankruptcy Procedure 3001, a claim is established by filing a proof of claim, and subsection F thereof establishes that the proof of claim filed in the bankruptcy court is prima facie evidence of the validity thereof. And your proof of claim stands as your claim against the bankruptcy estate for purposes of any pari passu distribution that may be had down the road, unless and until objected to.
Until what?
Unless and until objected to. There's a mechanism to object to proofs of claim. My clients filed a proof of claim. No one has ever objected to my client's proof of claim. So in the very narrow universe of the bankruptcy cases administration, when it comes time for the trustee to say, and I'm making up these numbers, I have collected $100 and I need to know who gets which piece of it, my client's claim is cemented and the trustee's distributions can and will be determined. Now, in the rest of the known universe, outside of the trustee's distribution in the bankruptcy case, we look what we traditionally look to, which is a judgment. But if the judgment is discharged, there's no point in proceeding. There's no point in having a trial to determine how much Mr. Bott owes Messrs. Caviti if Mr. Bott can never be called upon to pay that money, and if Messrs. Caviti would be violating the discharge injunction of the bankruptcy code by so much as endeavoring to collect upon that judgment. And there's ample case law for the proposition that a bankruptcy discharge does moot an ongoing effort to seek a judgment against the debtor who receives the discharge. Judge Rushing, I don't know if that answers your question or not, but...
I'm still pretty confused.
Okay.
Because he does, I mean, it's not that they're saying, even if they don't collect on it all, they can get some piece of the pie.
Yes, and they can still get some piece of the pie with the adversary dismissed. So had my clients never filed an adversary complaint against Mr. Bott, had they simply shown up and said, you know what, we think it probably is dischargeable and there's no point in getting a judgment, which, to be clear, is not their thought process, and they just filed a proof of claim, they would still get the piece of the pie. You don't need a judgment to file a proof of claim. Actually, much to the contrary, bankruptcies are very often filed on the eve of a trial or on the eve of a judgment or somewhere along the way where someone doesn't wish to be subject to the realm of a U.S. district court or a state court. So it is not unusual for creditors to go into bankruptcy without a formal judgment.
But then, I mean, I take your point. It makes it, why bother? You know, it's just efficient. But the point is you did bother, and you voluntarily dismissed it without prejudice, and you're retaining the right to reassert it if we rule in your favor on appeal on the other count.
Yes, Your Honor. And we bothered for a couple of reasons, but the most notable is efficiency. So my clients had already sued Mr. Bott in the District of Columbia Superior Court. In fact, there was a clerical default entered, and it was before a judgment upon that default could be entered that Mr. Bott sought bankruptcy protection in the Eastern District of Virginia. So my clients found themselves in the situation of needing to establish that the judgment would not be dischargeable in bankruptcy and needing a mechanism to reduce that obligation to an actual judgment that could then be collected upon after the automatic stay imposed by Mr. Bott's bankruptcy lapsed, expired, was waived, released, whatever it may be. There seemed to be a judicial economy in bringing it with the adversary proceeding. There were, in reality, two almost identical cases pending in two courts at the same time, but that made sense. To show a lack of dischargeability, we were going to have to touch upon the merits of what had happened and put on evidence in support of what had or had not happened. So it seemed to be judicially economical to, at the same time, seek the liquidation of the judgment. Once there was no way to have a judgment that could be collected upon, though, we were left with nothing. And even if we went back to the DC Superior Court action, we're left with nothing because we can't collect on a judgment. We can't even ask the DC Superior Court to enter a final default, or we'd be violating the discharge injunction. And I think this goes to this circuit's
Help me understand that, right? So I totally get that, right? So I think I agree with basically everything you just said, right? That it makes a lot of sense, it creates efficiency, and it'd be a good idea,
Yes.
right? The challenge is, like, none of those, like, govern,
Well,
right? We've got to have a final order in a proceeding, and Microsoft tells us you don't create one by voluntarily dismissing a claim, because practically it's not going to have, an effect, right? I mean, Affinity carves out this little narrow exception to Microsoft. One might say just sort of recognizes a narrow exception to Microsoft where the court's ruling legally eliminates the other claims, right, as a legal mandate. But this is just a practical problem, not a legal one. That's where I'm rubbing.
I actually think it is a legal one, Judge Richardson, and I think that's why it falls within the ambit of I love that the Affinity Living Group standard is the doomed standard. Your claims must be doomed as a matter of law. And my client's remaining claims were doomed as a matter of law because not only was there wholesale mootness, right? There was no case or controversy left. There was nothing to pursue, which I would argue means the bankruptcy court actually lacks subject matter jurisdiction. But let's assume there was subject matter jurisdiction, and let's assume that we did go to trial. My client's claims could not have ever had any material or legally cognizable benefit to them, detriment to the other side, or impact upon the world as we know it. If they received the judgment, they could not collect on it, they could not use it to attach an asset, levy upon asset, or even call up Mr. Bott and try to politely negotiate a payment plan. And if they didn't receive the judgment, the same exact thing would happen. They wouldn't have a judgment to collect upon, they wouldn't have anything to levy upon.
Does it matter that from a timing perspective, that the bankruptcy decision was not made yet? So in other words, the debts of the debtor had not yet been discharged?
And I believe the debts of the debtor had been discharged at the time that the bankruptcy court dismissed our dischargeability claim, and they certainly had been discharged by the time we entered into the joint stipulation. In the supplemental briefing, I attached the underlying bankruptcy docket as opposed to merely the adversary docket, as I suppose a supplemental appendix, and it notes the date of the discharge. I believe Mr. Fasano did the same. There's roughly a year's time between when the debtor received his discharge and when we entered into the stipulation and dismissal. But I will take your question the other way around. If the debtor had not yet received his discharge, then it would matter a great deal. Then there would be a case in controversy, and then there would be equal utility in pursuing the matter through the adversary proceeding or waiting to pursue it through DC Superior Court. And I'm not sure that I would be as confident in my standing as I argue here today if the debtor had not yet received his discharge.
Does it matter that was, help me with the trustee sort of finding error with the assets? How does that play into that story?
I don't think it actually materially impacts this because I think that solely goes to the trustee's distribution in the bankruptcy estate. And as I had begun to argue earlier in response to Judge Rushing's question, that's really governed by a Rule 3001 proof of claim and not the existence or lack thereof of a judicial judgment. So I think that is actually something of a red herring for analytical purposes. If my clients filed a proof of claim, which they did, and the debtor wished to take issue with it in the very narrow prism of the bankruptcy world, the debtor's prerogative actually would be to object to our proof of claim. Merely challenging our adversary proceeding to liquidate it to a judgment would not be sufficient. And under Rule 3001F, our proof of claim is the prima facie validity. The fact that this is a case that rocked back and forth where the trustee thought there was nothing and then found nothing, and the saga still goes on, I believe is ultimately immaterial to the posture of the adversary case and to the appellate jurisdiction that stems therefrom.
And is the debtor precluded at this point from objecting to your proof of claim?
I believe the debtor is pragmatically precluded at this
I
point.
get pragmatically precluded, right? 'Cause
But
they don't have an interest. But the question is,
if
or
the
the
debtor-
trustee, can anybody object to your proof of claim at this point?
Any party in interest would have been able to object to our proof of claim. Without looking at the docket, would need to see if certain things had happened. But what I would note would be any objection to our proof of claim would be a freestanding proceeding in the bankruptcy case unless and until consolidated with the adversary proceeding. And there certainly was no objection here, no consolidation here, et cetera. I recognize that there could be certain res judicata impacts and estoppel impacts that would stem from that. But there was no objection, and actually part of the stipulation of dismissal entered into observed that there had been no objection to my client's proof of claim, which is why we believed we were liquidated for purposes of the bankruptcy. And if we weren't able to liquidate a judgment for external purposes, there was no point in moving forward in the adversary.
How much money is involved here?
Your Honor, the grand sum of $58,770. And if I may back up a second, if someone were to object to the proof of claim, it would be in the bankruptcy where all parties in interest are on notice and where everyone has the ability to then file an opposition, be heard at a hearing, et cetera. It's worth noting that in the narrow lens of the adversary, the only parties were my clients and Mr. Fasano's client. So there is a somewhat different posture to how those two things would have been approached.
But if you've liquidated the claim, then an objection to your proof of claim is unlikely to go anywhere. The court has already adjudicated that in the adversary proceeding.
Your Honor, in context external to this case, I take great pride in my ability to creatively object to people's proofs of claim, and there are many grounds upon which it can be done. But yes, it is certainly a much stronger proof of claim if buttressed by an enforceable judgment than if not buttressed. I see I'm out of time, and I'll reserve for rebuttal, having perhaps not reached the merits of the appeal itself.
Thank you, counsel.
Yes, I should say, good afternoon, Your Honor.
Thank you.
May it please the court, Justin Fasano for Naveen Bhatt, the appellee in this case. Your Honor, the procedural in this question, the procedural issues in this case are a bit awkward. Both Mr. Verstandig and I are arguing the opposite positions as we argued in the bankruptcy court.
Indeed.
Yes. I originally moved to dismiss both counts. The substantive count, count one, for lack of jurisdiction, because at the time it was a no asset case and there was no point to adjudicating it. And we moved to dismiss the non-dischargeability account because we alleged they could not allege proximate cause. We won on the non-dischargeability count, but by that time the trustee had found the assets. He had arranged to buy out my client's equity in an LLC. And because there were assets, as Mr. Verstandig argued in his opposition in the bankruptcy court, then there was actually something to argue about over count one. Now there was going to be an adjudication of the amounts that were owed to Mr. Caviti because they had filed a proof of claim. And we filed an answer to the complaint after we lost on the motion to dismiss count one. So we contested liability, not just non-dischargeability. And so there was an active dispute. And frankly, my client does not have the resources that Mr. Verstandig's clients have. And it would have been quite burdensome, financially burdensome for my client to have to take that case to trial. And so we tried to come up with a creative solution. I had not read Microsoft versus Baker at that time. And we tried to come up with a way where we could present the court with this case without having to go through two trials. And so this is what we came up with. And having read Microsoft versus Baker, it does seem like this is a case where where it was certainly inefficient to try count one before the bankruptcy court, but it was not legally doomed. It was not a case within the framework of the Affinity Living Group case. They could have been successful on count one, the violation of DC Municipal Regulation 16.1-800, but they could have been successful on that count without being successful on count two, that my client lied about having that license, giving rise to the liability. So it is in almost on all fours with the Microsoft case. Microsoft case was a class action based on scratched disks. They were asserting that the Xbox software consoles were scratching the plaintiff's disks. And no plaintiff wants to take that case to trial individually. And the Cavities didn't want to take this case to trial, just for purposes of determining their proof of claim.
What's your thought on the mootness theory that, I don't know if it's mootness or that the court actually lacked jurisdiction once the debt was not dischargeable? Your friend on the other side says once the court ruled that the debt was dischargeable, then it was moot to decide count one because we have a proof of claim and the debts had already been discharged.
It would not have been moot. It would have been moot if there were no assets.
Right.
But since there were assets, it is not moot because the adjudication of that complaint would be res judicata for determining whether or not the proof of claim was allowed. So we would have theoretically litigated this to full judgment on the liability issue, not the non-dischargeability issue. And then I would, if I won, I would have filed an objection to the proof of claim. And if I lost, the proof of claim would just stay allowed. But it's certainly not moot, and in fact, that was the argument that the Cavities made in their opposition to the motion to dismiss, was that it was not moot because there was a proof of claim on
If
file.
they could have voluntarily dismissed it with prejudice.
I don't know that they...
Now, that's not what happened, right? You guys were very clear that this was without prejudice to further proceedings if we ruled differently, and that would have been a different question for finality. But,
If they had dismissed count one with prejudice, I think they could not proceed with count two.
would they still be able to use their to proceed with the proof of claim?
Yes.
Because you wouldn't have gotten a victory on the merits that you could hold up as, as an objection, I guess, however you want to phrase it, to the proof of claim, right?
They would have still been able, their proof of claim would still be deemed allowed until we objected to it. And then there would be an adjudication of the objection to proof of claim if we chose to do that. But,
So, let me just rephrase that to make sure that I'm understanding what your position is. So I understand your colleague to say, once dischargeability is decided, count one, there can be no redress of their injuries, in essence, because their proof of claim is going to get them whatever residual assets they have a right to, and that's all they can get in the bankruptcy. And outside the bankruptcy, it doesn't have any impact because it's dischargeable.
correct, Your Honor.
So so why then, I mean, that's not technically mootness, but maybe we say in that context that count one is, there's no jurisdiction over count one once count two is resolved because count one, a ruling on count one can't redress any of the injury.
But count one was not moot because it'll redress part of the injury.
In what way? That's what I'm trying to ask.
Because they'll receive a distribution of the assets based on the allowance of their proof of claim.
But they're going to receive that. Let's imagine instead what they did is they dismissed counts 1 and 2 in total, or they just never filed them, right? But if they dismissed both of them, wouldn't their proof of claim entitle them to their share, whatever that is, of the state's assets?
Unless it was objected to.
Unless it was objected to. And if it's objected to, then it would be resolved.
Right.
And your point is the difference that it would make is that if you had a resolution of count one in the adversary proceeding, in the proof of claim proceeding, that's maybe not certainly going to be enough, but that's going to solidify that proof of claim.
If, I would assert that they're identical. The allowance of liability is the same as, the finding of liability is the same as the finding of liability in the adversary proceeding is the same as finding liability under the proof of claim. All you're doing is finding whether or not there's liability. So I would assert they're identical.
But we don't typically think that a claim would redress the plaintiff's injury where the only thing it would do is have an impact on other litigation. And admittedly, this is odd, but that's just because bankruptcy is odd.
Understood, Your Honor. What I think the answer is that they were required to litigate all of the counts that they brought in their adversary proceeding to completion before they can appeal. And because there was an underlying issue, because there was still subject matter jurisdiction over count one, because it's the functional equivalent of an objection to the proof of claim when I filed my answer, then they have to litigate count one to completion, according to Microsoft versus Baker and Kena versus Groupon and that line of cases. It's not the rule I would have invented. I certainly think it would be more efficient if we could have just appealed this up to the Fourth Circuit without having to go through trial. But my client's just as happy to stumble his way to victory as he is to get there on the merits. There's simply, I don't see a distinction from Microsoft versus Baker at the end of the day. I don't see a distinction from Kena versus Groupon. And it's not like...
the distinction your colleague wants to argue is the doomed exception, right? Or that the count one is doomed. It can have no impact in the real world because the proof of claim is already filed on the, estate's assets, and count two means outside of the estate, he can't do anything with it. And so perhaps that's a pragmatic dooming instead of affinity, which was a legal dooming, but maybe that doesn't matter because redressability has some pragmatic aspect to it. Unlike Microsoft, where it was still redressable, right? The individuals could still get money on their claims.
Well, and this is still redressable. He could still have gotten money on his proof of claim. And if we don't object to the proof of claim at the end of the day, he will get money on his proof of claim.
But he's not yet gotten money on the proof of claim. Nobody has gotten money on their proofs of claim yet.
No, they have not finalized the bankruptcy. They can't do that until this is all resolved. So, as a practical matter. But
Are you or anybody else, and then I'll let you keep going, sorry, but are you or anybody else precluded from objecting to the proof of claim at this juncture? Like if you just decide, if we rule hypothetically that all of these go away in some magical way, could you then go and object to the proof of claim?
absolutely. There's no time limit to objecting to a proof of claim. As a practical matter, we chose just to do this appeal. But
It's effectively the same thing. One way or the other,
Yes.
if you win on count one, you're going to win on the proof of claim, whichever side prevails.
Exactly, Your Honor. Your Honor, I hope that's addressed the procedural issues before the court. I'd like to get to the substance of the matter.
I just want to be sure that I understand what your position is with respect to, you think we do or do not have jurisdiction here? Just tell me that.
I don't believe you have jurisdiction under Microsoft versus Baker.
Okay.
Yes. And I think the justiciability determination rests on the, I do believe that if you find it's more akin to affinity versus then there is justiciability, but I think that requires you to find a final order under Microsoft versus Baker, and having read Microsoft versus Baker, I don't get there. I think there's certainly more, there was certainly more at stake for the Cavities, trying to litigate the liability under the proof of claim. There was certainly more at stake economically than there was available for the plaintiffs in Microsoft versus Baker, who were suing over scratched CDs. And the Supreme Court said, no, you have to take.
Maybe, that's the question. I mean, that's actually, I think, the question, right? Because in Microsoft, they were going to get $1, whatever it is. And like $1 is real. Like the question is here, is the resolution of count one going to make a literal red cent difference?
Yes.
And help, just one more time, and then I'll let you talk about the other stuff. But one more time, tell me, where is the red cent? Help me find it.
Okay. If their claim is allowed, then they are entitled to a distribution from the pot of assets that the bankruptcy trustee has found. If their claim is disallowed, they're not entitled to a distribution from that pot of assets. So the pot of assets is $15,000. That's what my client's partners in an LLC bought out him from the trustee. So there's $15,000 there. Let's say there's, I don't know the amount of claims in the case, but let's say there's a.
I get this, I get that far, right? But why is the resolution of count one gonna matter there? Because he's got a proof of claim. It's almost like he got two ways of getting the money. One's the proof of claim and one's the count one. Right? But they seem duplicative of each other. And maybe, I mean, there's nothing wrong with that. You can bring a state court suit and a federal suit for the same thing. So you can bring an adversary proceeding and a proof of claim proceeding, not really proceeding, but anyway, you could bring both of those to reach the same end, and whichever one wins first, he'll take the money either way.
And as a practical matter, if a trial on count one went forward, we probably would have consolidated with an objection to the proof of claim. But that's not what we chose to do. The adjudication of count one in the adversary proceeding is 100% absolutely determinative of liability under proof of claim. They're the same issue. If you're not liable under count one, there's no liability under the proof of claim. They're not entitled to any distribution. And that's what they argued to the bankruptcy court. That's why they said the bankruptcy court still had jurisdiction over count one when they opposed the motion to dismiss. And that makes sense. And when we moved to dismiss, we were thinking it was a no-asset case. I don't think I would have been able to make that argument had I known that there were going to be assets in the case, because we would have been stuck litigating the amount of the proof of claim.
Happy to give you a few minutes to talk about the merits.
Thank you, Your Honor. The underlying statute that the plaintiffs are suing under is a strict liability statute. It's not, it says if you take advance payment of any deposit for home renovation work in the District of Columbia and you don't have a license, you have to give it back. It doesn't matter if you did the work, doesn't matter if you did the work competently, doesn't matter if you knew about the licensing regime. It doesn't matter if your customer knew you were unlicensed. You simply have to give all of the money back without set off for the fact that you paid your subcontractors all of the money, without set off for the fact that you were unpaid certain amounts due under the contract. It is a strict liability statute, and liability is imposed without regards to any fraud performed by the contractor. My client had a Virginia contractor's license. That's not a defense. This is all set forth in the case of Nixon versus Hansford. And the plaintiffs call that, they say it's an intentionally draconian statute, and I agree. But the very same draconian nature of that statute belies any argument that any fraudulent misrepresentation alleged by the plaintiffs is the proximate cause of any disgorgement damages that the plaintiff is seeking. They are not seeking damages for faulty construction. They haven't chosen to make that claim. All they are seeking is disgorgement under a strict under a strict liability statute. They're not saying, we paid $58,000 and the work done was only $25,000. They're saying, he didn't have a license, he told us he didn't have a license, he told us he had a license, therefore give us back $58,000 for fraud. Now that license is not any indication of competence in the field of contracting. You don't have to take a test to get that license. You don't have to apprentice with anybody. You don't have to have any experience as a contractor. What you have to do is you pay a fee, you post a bond, and you get property damage insurance and public liability insurance. There's no determination that you're competent as a contractor. And so for the Cavities to say that they relied on that, that's the same argument that was made in the In re Carpenter case in the District of Columbia. And In re Carpenter followed the case of In re Sabin from the Ninth Circuit and said these strict liability licensing regimes simply do not give way to a fraud judgment under Section 523 of the Bankruptcy Code. If Mr. Verstandig's clients could show that my client said he was experienced and he had, say, a Virginia license, which requires an examination, and he lied about that, then that would be a material misrepresentation. That is, and if they suffered actual damages, which is not part of their complaint. All they're seeking in this case is the disgorgement of the $58,000 that they paid my client in advance. And my client worked on that project for over a year. And the representation that he had a license simply could not be the proximate cause of any disgorgement damages that they could allege. The representation of competence would be a different thing. The representation that he had, like in the Pleasance case, where he said, I've been a licensed architect for 20 years with all this experience, that would be different. But a DC license, which is basically just you pay a fee and you get it if you don't have a criminal record, it's only meant to protect against fly-by-night contractors who are looking to take the money and leave. That's all it protects against. There's no insurance for shoddy work, which is the damages that they allege. I see my time is up, so I will rest my case.
Thanks, counsel. Before you turn to the merits, can you start by talking about your representation to the court that even if the debt was found to be dischargeable, as it was, that you were still entitled to success on count one because, quote, there will be, in fact, monies to distribute from this estate?
Yeah.
Right, that's the argument, it seems to me, that fundamentally the adversary proceeding is the corollary to the proof of claim.
Your Honor, the easiest answer to that is the one I like giving the least. I was wrong. I was wrong there and I'm right now, and Mr. Fasano was right then and he's wrong now, but let me give the easy answer. He had indicated that if he prevailed in the adversary proceeding, that would have served to defeat my client's proof of claim. While he's pragmatically correct, he's technically wrong. There is one step, albeit perhaps a ministerial one, which is he would still have to object. Now, I'll admit, if we lost on the merits, the objection would be, res judicata would reign supreme. It would be fait accompli. But he would still have to object. A notice of objection would still have to be sent to everyone. There would still have to be some hearing or at least some order passed. And I am not aware of any precedent, and I think this was intimated by one of the questions, where a case or controversy is found to continue to exist in one judicial proceeding solely for purposes of imbuing another proceeding with res judicata. That is an entirely wayward concept and one that admittedly stretches my feeble mind perhaps further than it ought to be stretched. And I do not know that that's really a case or controversy within Article 3's.
Well, isn't it you could litigate count one and have a jury or the court say you are entitled to the money. Mm-hmm. And that's redressability, right? You say we want the money and you could have a court say you get the money. Or you could wait and just put forth your proof of claim. But how does the fact that there's an alternative way you could decide to do it make the count one option lack redressability?
Your Honor, there's a third way we could have done it too, and I think that goes to the answer. I could have sought stay relief and asked.
You got to.
I'm sorry. There's a third way we could have done it, and I think that goes to the answer, which is we could have simply sought stay relief for purposes of having the Superior Court of the District of Columbia enter judgment in the pending action there, which was fairly far along. Now, let's assume in a hypothetical universe that's what we did. So we filed a one-count complaint to establish that the obligation is not dischargeable, and we sought and received stay relief to go liquidate the obligation in D.C. Superior Court. Once the bankruptcy court ruled that it was dischargeable, the D.C. Superior Court case would have become moot. I understand the same res judicata argument could be made for purposes of a claim objection, but it's a very different standard on a claim objection. Burdens are different in the context of a claim objection. And again, I go back to, I don't believe that proceeding with adversarial litigation merely to maintain a res judicata posture in a similar but distinct context is consistent with the
Does
article.
it matter that they're part of the same case? So these are different proceedings that are part of the same case, right? And so I get your point, and maybe you're right if the proceeding was in the D.C. Superior Court, right? But they are different proceedings, but they are all part of the one bankruptcy case, right?
Yes.
And so that's like, the court is like deciding right hand, left hand. They're different proceedings, but they are the same case.
Yes, Your Honor, but I don't believe that is not technically true. I don't mean to dispute the obvious. But an adversary proceeding has its own case number, and more importantly, it has its own service list. If I were to file a motion in the adversary proceeding, CMECF would send a copy to Mr. Fasano and presumably to the clerk and someone in the judge's chambers. If I were to file a motion in the main bankruptcy case, Mr. Fasano would get it, the trustee would get it, every other creditor who entered an appearance.
So that's pragmatically fine, but it is odd to think about this in context. It's one case. So if the district court was deciding, had both a TRO and a preliminary injunction in front of it, right? The fact that one might solve or the other might solve doesn't change it because it's all part of the same case. And this is like, I think I get your argument if we're in D.C. Superior Court with the claim and you sought a relief from the stay. But given that we're part of the same case, I'm having a little trouble understanding why we ought to think about it that way.
Your Honor, the reason I made the serviceless comment is because if we succeeded in the adversary proceeding, it would not have a preclusive effect upon an objection to our claim brought by any other creditor or of a trustee. Because only...
Unless they had actual notice of it, right? So unless they were following the bankruptcy.
Yeah, which, would be a fact-intensive thing. I recognize I've gone over my time. May I give...
I will definitely give you a few minutes to talk about the merits of your claim, if that's okay.
Thank you, Your Honor.
I mean, it seems only like marginally fair, but please go ahead.
Very basically, 523A2 provides that any debt for money to the extent obtained by false pretenses, a false representation, or actual fraud, end quote, is not dischargeable. The majority of case law talks about actual fraud. Much of what we briefed deals with actual fraud. And I think that does a fundamental textual disservice to the words false pretenses, a false representation, and or. You don't need to have a claim for fraud, which means you don't need to prove the elements of common law fraud to establish non-dischargeability. You must merely show that there is a debt, that it is for money, and that the money was obtained by false pretenses.
Do you agree that that last piece includes a requirement that the misrepresentation proximately caused the damages? That's what all the other courts say.
Your Honor, I don't agree, but even if it did, I believe that the reasonableness of reliance would be a question of fact for the fact finder, and thus it would have been inappropriate at the 12B6 stage to dismiss this. But I don't believe that. I recognize that is what a number of courts have said. We have pointed to the world's shortest Southern District of New York opinion that is, I believe, all of 6 sentences that seems to intimate that you must only show transactional causation and not law's causation without any explanation thereof. And I will handily admit that is the only authority I can point to other than the text of the statute itself, which is the authority I'd rather have. The word or must have some meaning. And if we're merely going to conflate false pretenses and a false representation with the words actual fraud, we have discovered a healthy amount of surplusage in the bankruptcy code, and that doesn't seem a sensible means of going about it. I'd also note the De La Cruz court said that the statute is to be, quote,
It's not just conflating fraud with misrepresentation. The words are obtained by, right? Obtained by misrepresentation or fraud. And so does obtained by include a requirement that one proximally caused the other? You obtained it by your misrepresentation.
You know, I would agree that if Mr. Bott had said to my clients, I'm an unlicensed contractor and I'm a New York Yankees fan, we could not bring suit if it turned out he was a Mets fan. That would not get us anywhere in a 523 prism. So I think there does have to be some causal nexus that must survive a motion to dismiss. But here my clients have plainly alleged that they would not have hired Mr. Bott but for the representation of licensure. Now, the comeback through the case law has been, well, is that representation and reliance a reasonable one? Should we be relying upon his claim of licensure, or should we just acknowledge that understanding whether someone's licensed or not in the District of Columbia is of no moment whatsoever? And it seems to me that is, at best, a question for the fact finder, and at worst, not grounds upon which to disrupt a 523
But the point
claim.
is that it doesn't matter for proving your DC claim, whether they relied or didn't rely, or it was reasonable or not reasonable. No one has to prove that to collect this disgorgement.
Correct, Your Honor. So there's a Supreme Court case, which is Archer v. Warner from 2003. It's a Breyer opinion, where someone had brought suit for fraud and they settled. There's a settlement agreement. It contains global mutual releases and an obligation to tender funds thereunder. And lo and behold, there was a breach of the settlement agreement. And the obligated party filed bankruptcy relief upon owing about $100,000. And the question in front of the Supreme Court was whether or not that obligation is subject to 523A2, because it's not a debt for fraud. It's a debt for breach of contract. In fact, any claims for fraud have been released, waived, and let go of through the settlement agreement. And the Supreme Court found that it is within the ambit of 523A2. I'm 4 minutes and change over. I think that's further than I bargained for, but
But the difference is, with that Supreme Court case, right, they had to prove that there was some, it's not strict liability, right? They weren't talking about this DC municipal code.
correct. We will still have to show that there was a false representation. We still have to show by a preponderance of the evidence that Mr. Bott lied about being licensed, and we also will have to show by a preponderance of the evidence that we would not have engaged him but for that lie. I agree, we've got our work to do once we clear the motion to dismiss. But I maintain we are entitled to clear our motion to dismiss and have a fact finder make these determinations, Your Honor.
Thank you, counsel. We'll be happy to come down and greet you, and then the clerk can adjourn court for the day. More than you bargained for, I know.
Good afternoon.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.